So again, good morning and welcome. My name is Jackie Pasley and I'm your host in today's session. We have our facilitator who you can see on screen. She is here. She's Emma. She'll tell a little bit more about herself shortly. She's ready and raring to go. Can't wait to share the information that she has with you. But before she does, I'd like to take some housekeeping and administrative matters out of the way. So for the persons who are wondering why they are muted, this is because we have intentionally muted the microphones, and this is just so that we can have some order in the way we facilitate our training session today. Allow me to share my screen, and and I'll be able to talk you through a few things that we would like to share with you so that we're all on the same page on how the sessions will run. I see some familiar names in the chat, so I know some persons have been in some of our other sessions, so I'm sure you know the drill and the routine, but for the benefit of the persons who are joining us for the first time, as I alluded to earlier, we have muted your mics and disabled your videos. This is just for the first 3 hours of the session. And this is to allow the facilitator to be able to share the information that she has to share. We are very interested, however, in your questions and your comments. And so we invite you to post those in the chat and in the Q&A. If you're not sure where those are on your smart device, I'm going to ask you to just take a few seconds now to identify them. And so please, we encourage you to ask all your questions, put all your questions, all your comments in the chat as well as in Q&A. We also have a raise hand feature. Feel free to use that feature as well. If it is that the facilitator may need a little bit more information to answer a question, we are in a position to enable the mic so you can speak to provide additional information so that she can appropriately answer any question that you might have. There will be a session break somewhere around an hour or 50 minutes after we have started. And this will allow you to refresh yourselves. Please don't leave us for too long. We want you to come right back because we certainly want you to benefit from today's session. At the end of the training, we have 2 forms that we will administer. One is a feedback form, and this feedback form, the link to access the feedback form will be placed in the chat. I will advise you once it's in there so you can head to the chat and complete the feedback form. This is very, very, very important information for us, very critical to us. So we encourage everybody that's in today's session to complete the form at the end of the training. It provides information on what we're doing well and stuff that we may need to improve on as we continue in our thrust to provide quality and seamless training sessions to you. The second link is a link to access the quiz, a short quiz, and not hard, right, Emma? Very, very easy quiz. And because we want to get a sense of how much you've understood from the information that was shared today. Certificates will be issued at the end of the program, and so we encourage you to do the quiz because this determines the kind of certificate or the type of certificate that you get. And in closing out this part of what I have to share with you, I just want to encourage us all to have fun. Our sessions have been really engaging, the ones that we've facilitated before today. We anticipate that this one is going to be no different. And so learning doesn't have to be boring. It doesn't have to be mundane. It can be fun, and we are all going to make it fun today. Just to put a little bit of context and background behind today's session, the American Friends of Jamaica, Fresh Milk, and Kingston Creative came together to bring this very exciting initiative to creatives across the Caribbean. It came out of the need of the challenging times that we all have been facing since the onset of COVID. And the primary objective of the Catapult program is to help persons to navigate the digital space, to further network using the digital space, and to create a presence, and of course to earn more as well using this space. And so we have 6 initiatives in the Catapult program, and the digital creative training is one initiative of that program. In the digital creative training, we have 6 modules, and today's module is entitled protecting and benefiting from your intellectual property. Lots to learn. It's a very, very important topic. A topic I think that some persons kind of shy away from, but it's a very important one if you are going to excel in your business. And so I encourage you to get as much information as you possibly can out of this session. This is where I'm going to take a break, and I'm going to hand over to Emma, our very able facilitator. And at the end of the session, I will come back to you and share a little bit more about how we will do things on the back end or later on in the session. Emma, over to you.
Thank you very much, Jackie. I'm going to share my screen now. Okay, good morning, everyone. You should now be seeing a PowerPoint presentation entitled Protecting and Benefiting from Your Intellectual Property. Just checking that everyone is hearing me and that you are seeing the presentation.
Yes, we are seeing and hearing.
Okay, great. So good morning, everyone. Thank you very much for attending this morning's session on protecting and benefiting from your intellectual property. A very important topic, and as Jackie mentioned, a topic that some people tend to shy away from. However, a topic that should not be ignored because it is a very important field for those who want to generate alternative revenue streams and protect their products or protect themselves, as the case may be. So within this session, we are going to do several things. Jackie has already told you about the Catapult program itself and the organizations. So I will go on to what we are going to achieve today. In this session, we are looking at 6 topics. Topic 1 is going to be the most lengthy. This topic 1 looks at all the different intellectual property rights that are most important to creatives. So within that, we will cover several rights. After that, it should be fairly smooth sailing, as the first part is the most technical part. When we establish the rights, we'll look at why is IP important, how can I protect my IP, what are the limits of IP, good practice for online management of IP, and important Caribbean agencies that Caribbean creatives should be aware of. If at any point you have questions, you can please use the Q&A feature, but I will have intervals for questions after each section, just to make sure we have a good flow, and that everyone can take some time to absorb the information and then ask the questions. That being said, if you want to ask before that, that is fine as well. Okay, so a bit about me before we begin. So I am a director at Global Consultancy based in Trinidad, and we provide intellectual property advice and management services. I'm also a lecturer in law at UWI St. Augustine. So I've been teaching online since March, so I'm not new to this online environment, and I know that 3 hours can be a long time to pay attention to something in the online environment. So I'm hoping we make this fun and interactive and that you can enjoy the information and also learn at the same time. In terms of my qualifications, I have my LLB, which is my undergraduate law degree from the University of Kent in England. I then went on to do my LLM in intellectual property at University College London. I then did the bar professional training course where I was called to the bar at Lincoln's Inn. And then most recently, I completed a PhD in intellectual property from King's College London that was awarded this year. Unfortunately, my certificate has not yet arrived because Trinidad's borders are closed, so international mail cannot get here. But I am glad that I have been able to complete that this year despite COVID challenges. And I know we're all facing many challenges in this very unprecedented situation. So in addition to my lengthy experience in education, I also have practical experience. I have acted as a team advisor for a patenting process for a non-invasive test for determining prostate cancer. I've also drafted written submissions for an intellectual property moot, which is similar to a mock trial. When I was in the UK, I was a director of Own It, which was a pro bono organization. In other words, they gave free advice to creatives, especially for those who could not necessarily access very expensive legal advice in London. And more recently, I have moved back to Trinidad as of December 2018. And now I advise small, medium enterprises as well as individuals on their IP strategy, not just within Trinidad, but also regionally as well. Since I have come back, it has been one of my goals to really develop accessibility to IP being intellectual property, because I think we have so much potential in the region, and we really need to do our best to make sure people can understand how they can make the most of their potential. And IP is one of the key tools in making the most of your potential as a creative. Okay, so I'm talking about IP, intellectual property, but what does that mean? So this is actually a very broad term that can refer to many different rights. Generally speaking, the World Intellectual Property Organization uses this definition that's on the screen. IP refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. So you can see from that definition alone that IP is obviously a very broad field with many, many different rights. Some of you who have heard of intellectual property before may have seen some of these symbols. Has anybody seen any of these symbols? Does anybody know what these symbols mean? You can use the chat and I'll be able to see your responses. Have you seen these symbols? Do they strike a memory? Do you have any idea what these symbols might mean? Yes, correct, TM is trademark. Yes, we have the C for copyright. Yes, we have registered and unregistered trademark symbols here actually. Okay, so I'm seeing some people say they know about patents, some people saying knowing about registered trademark. All right, great. So the R in the circle is for a registered trademark. And we're going to be looking at registered versus unregistered trademark in the course of today's workshop. The C in the symbol is for copyright. That's one of the most extensive rights that we'll be looking at, one that is very, very important for creatives. The TM also relates to trademark, but it is for unregistered trademarks. So we have registered and unregistered. And patent pending is one that is less relevant for creatives, not one that we will be looking at today, but it is something you might have seen. That is when somebody applies protection for an invention. So these are things that you might be familiar with. And if you have seen them, it goes to show that IP is everywhere. That is what makes it so important. It literally can impact every aspect of your daily life. Any product that you use, any music that you're listening to, any artwork you view, there is some form of intellectual property involved. Okay, so these are different types of intellectual property rights. We have trademarks, copyright and neighboring rights, patents, trade secrets and confidential information, persona rights, also known as image rights or publicity rights, industrial design rights, and geographical indications. So some of you may be familiar with all of these terms. To others, some of these terms might be new. Now, these terms all have different applications. So we are going to be focusing on those that are most relevant to creatives in the region. But it's good for your general knowledge just to know that intellectual property rights span across many things, very, very broad concept, and they're very great variety of things that can be protected under intellectual property. Okay, so out of all those that I just mentioned on the last screen, which ones are most relevant to creatives? Well, we're going to be focusing on copyright, first of all, then go on to trademarks, persona rights, and design rights. Copyright is one that many people may have heard of or may be familiar with. Copyright can exist in things like song lyrics, music, art, sculptures, scripts, novels, even a PowerPoint presentation. Trademarks, again, are ones that people probably are familiar with. It exists, the trademark exists when you have certain meanings being attached to a logo or a brand. But of course, not all logos and brands are registered. So we'll be looking at registered trademarks as well as unregistered and the benefits of registration. We then have persona rights, which may not be as familiar to people, but persona rights are about the right to protect yourself. So your personal image, your name, your likeness, your features from unauthorized commercialization. And this becomes very important for things like endorsement and merchandising. So if you're entering into an advertising deal, you want to be getting paid for the use of your persona in that deal. We then also have design rights, which are not frequently discussed, so I suspect people might be less familiar with design rights, but these are rights that can apply to the visually aesthetic aspect of a functional creation. So often design rights can apply to things like jewelry, fabric prints, and other visually attractive pieces as they apply to a functional object. So design rights are less spoken about. They're also a bit difficult to use in terms of getting protection, but they can still be relevant. For some people, as I know, we do have people doing jewelry and people doing certain prints in today's session. All right. One thing that is very important to note about IP is that to fully understand what you're doing, to fully have a proper commercial strategy, you need to be aware of the laws in whichever country you are dealing in. And in the online environment, you can imagine that that means there's many different laws you have to be aware of. What we are doing today is going through the general principles. So these general principles will often be reflected in the laws in different countries. However, there are variations. So the law in Trinidad is not going to be the same as the law in Jamaica or the law in Barbados. The overall principles are likely to be the same, but there are going to be different variations with regards to offenses, exceptions, what comes within the law, what falls outside of the law. So while the principles we look at today are the general principles, they are relevant for your knowledge. To really have an in-depth knowledge, you need to be aware of the law in whichever country you are dealing in. Of course, in the online environment, this to mean that many different territories' laws become relevant. So please do keep that in mind. IP laws vary from country to country. Okay. I'm sure that you've already guessed before I went to the slide that this can make things very complicated, and indeed it can. So again, this is merely a word of warning so that you are aware that you do have to be up to date with whatever law you're looking at in whichever country you are in or whichever country you are dealing in. So we have an example on the screen here. Let's say you're based in St. Lucia and you upload a photo to Instagram. Instagram, of course, is accessible in most countries, which means if your account is public, many people are going to be able to access this. If someone in France then sees this and puts it on their blog, you are obviously going to want to know what redress you have because your copyright has been infringed by this act. Again, we go on to copyright shortly. The relevant law that would apply in this situation could be the law in France, where the screenshot was taken and uploaded. It could also be the law in countries where the website is targeted. So for example, let's say the website is in French. French-speaking countries might be the targets of that website. In addition to any country where the work is accessed, so even if the website is in French, if the work is being accessed in Barbados, where it's English-speaking, there's a potential for the law to be applying there as well. Now, the point of today's session is to, yes, familiarize you with the laws, but to figure out what you can do to protect yourself so you don't necessarily need to go all the way to litigation. Suing is very, very rarely the answer. It's very expensive, it's time-consuming, and for many matters, it's just not practical. So today, what we're aiming to do is generate awareness of your rights, understand how intellectual property works, but also, most importantly, understand the practical steps that you can take to protect and commercialize your rights. Okay. The best approach to an IP strategy is to be proactive. That means putting things in place, including the measures that we will discuss today, to make sure you are protected and to make sure that you are not infringing on anybody else's intellectual property. I'm seeing a question, so let me just check here. Okay, so Charlie, I will move on to this question when we go into copyright, just to give some context to the question, okay? But I have noted your question, thank you. Okay, so yes, in terms of intellectual property, it's very important to be proactive, try to protect your rights, try to make sure you're not infringing anybody else's rights. And this makes it a lot easier rather than waiting for something to happen, then starting to think about intellectual property. If you get to that point, it ends up being a lot more difficult to deal with your rights. So it's good to be aware from the outset. And clearly you all are here to generate this awareness, so you're already taking the right steps. If you really have serious intellectual property issues, or intellectual property is a very key part of your business, you do need to be doing further research or seeking professional advice. The information here is a good starting point, but do remember that intellectual property is a very, very complex field with many different aspects, even within each right that we're going to look at today. Okay, so let's go to copyright. Okay, so copyright protects different categories of work. These categories are literary, dramatic, musical, artistic, and audiovisual. So in copyright, you can protect sound recordings, broadcasts, software, photographs as a few examples. So we can see already that copyright has very broad reach in terms of what can be protected. So in terms of each of these categories of works, we have many things that can come within them. So in literary works, we can have poems, the script for a play or a movie. Your favorite novel is protected by copyright. Even speeches are protected by copyright. Even things like information on websites. So when you go to a website, there's information on that website that can be protected by copyright. Recipes can be protected by copyright. So for those of you who have a cookbook at home, if you turn to the front, you will see a copyright notice. Even these slides can be protected by copyright. We also have dramatic works, so things like plays, any kind of choreographed work that might be presented count as a dramatic work. Art, of course, can have many different interpretations. Things like sculptures, drawings, paintings, things created by artists can fall within this very broad category of art. Then, of course, music. Music can mean the background music, the lyrics, the actual singing of the song. Many different things can come under music as well. Then, of course, we have audiovisual works, which might incorporate different features. So videos and films, for example. So now I'm going to play a video via my share screen. And we're going to see if we can identify different copyright works in this video. So let me just change my screen to get that. All right, so I am going to play this video now.
Staggering numbers across the country is grounding its entire fleet.
Global cases rising above 650,000 with more than 30,000 dead.
It really just feels like it's too little too late. We knew it was coming.
Stay home. You still wanna go outside? You seen what going on out there? Like you're no common sense, or? Boy, quarantine up everybody off of the road, you know. Rolling on. The virus taking over the world, you know. World, you know. We can't party, no party. Stay at home and practice good hygiene. Wash your hand with soap and water. Don't forget hand sanitizer. Oh, Lord. Yeah. careful what you touch. Social distance can't rock so much. The fake news have to stop. You're making it worse for all of us. The whole world want to party, think it over while we wait on the vaccine. No vet till we deal with corona. The pandemic soon will be over, so we inside for a short time, yeah. No fight, yeah, alright, yeah. So we inside for a short time, yeah. No fight, yeah, alright, yeah. Watch me good, do not come out, knock about it, knock about it, spray about it. For them germs, it's trouble. Spray about it, spray about it, spray about it. Do not come out, knock about it, knock about it, spray about it. For them germs, it's trouble. Spray about it, spray about it, spray about it.
Okay, so let me just switch back to the other screen. All right, so hopefully all of you were able to see and hear that video. What do you think were the different pieces of copyright?
A little louder, Emma. We can hardly hear you.
Okay, are you hearing me better now?
A little faint.
Okay, what about now?
Still a little. It's still a little low. You need to increase the volume. I'm not sure.
I have my volume.
All right. So I'm told you're good on the other end. Somebody else is saying you're good. So you continue.
Okay, sure. Thank you. All right. So I was just asking, hopefully you're all able to see that video and hear the video. Yes, the Prime Minister's speech could be an example of copyright. I'm going to try to talk a bit louder. So apologies if I sound like I'm shouting at some of you, just so people can hear. So yes, Natasha, the Prime Minister's speech would be something that could be protected by copyright. Correct, Farrell, the music, the overall video itself. So I'm seeing we are having some audio issues. Yes, correct. Jan, the original videos he used from other people. Indeed, the Lysol logo, Netflix logo, all the logos that were being used. So we see that there are actually many, many pieces of copyright within that one video. So while the video itself is protected by copyright, there are also different copyright works within that video. I'm just going to see if I elevate my laptop, if maybe that will help with the sound. Okay, so hopefully this has helped a bit with the sound. I'm very close to my laptop now, so hoping this has helped.
Much better.
Okay, great. Okay, nice. So using a textbook to prop up my laptop has improved the situation. Great. So you all have identified very many pieces of copyright work, and this is something key to remember. When you are using different pieces of copyright work in your own work, you need to make sure you are getting the permission to do so, unless you can avail of one of the copyright defenses. So one of the advantages of the video we just looked at is that it is a public service announcement. It's a music video about COVID, and generally speaking, within copyright, there are educational exceptions that video will be able to avail of. If, however, you're making an advertisement, things are a little different. So you need to be very careful in terms of when you're using different copyright works. And again, this is something we will be considering today. But very good job in identifying the different pieces of copyright within that video. And hopefully you all also enjoyed the video. For those of you who haven't seen it before, it's quite a fun video, a nice PSA for a very terrible situation, but it does get the message across. Okay, now who owns copyright? Generally speaking, the owner of the copyright is referred to as the author. This is the first starting point. So the author is the person who makes the work. So whatever the work is, if the work is a painting or the work is a music video, the person who creates that piece of work is the owner. Now, if your country has a works for hire provision, this basically means that if somebody paid for the work, the person who paid is going to be the first owner, unless of course you have a contract that says otherwise. So the starting point is that if you create the work, you are the owner. Owner, also called author in terms of copyright. So for example, you're a photographer, you take photos, you are going to primarily own those photos, unless in your country there's a so-called works for hire provision. If there's a works for hire provision, the person who paid you is going to be the first copyright owner. This is why it's very important to be aware of the different laws in the different countries that you work in. Of course, there's also the possibility that your contract, if you're working with somebody else, is going to say who's going to have ownership. When using a copyright work, if you did not create it, it's very important that you determine who the owner is. Because the owner is the person who is going to have permission, rather have the responsibility of giving permission to use the work. So you need to determine who is the actual owner of the copyright work. Could be the person who created it, but that person might have also then sold that copyright work to somebody else. And if they sell the rights in it to somebody else, then the person who now owns the rights is the one you need to seek permission from. So we can see already that copyright can be a little complicated because of the different ownership possibilities. Also, if you create a work with another person, you might be joint owners. Being a joint owner, again, has different implications in different countries. In some countries, joint owners need to agree on how the work is being used. In others, one of the joint owners can proceed to use the work without permission from their partner. So it's very important to think about joint ownership status and be aware of the law, whichever country you are creating joint works in. Okay, so then how does copyright exist? Because we talked of loads of different things that copyright may be present for, but how does it exist? The formal term for the existence of copyright is known as originality. Now, originality in this sense is not the way in which we might think of originality on a day-to-day basis. It basically means that it is not copied from somewhere else. By copied, we mean that most of it hasn't been copied, as in you haven't taken a chunk of somebody else's work and then tried to say that it is yours. So this originality standard is actually very low. It means that most work is going to be subject to copyright. It is a strange term considering the way in which we use originality in our daily lives, but the important thing to remember for you is that generally speaking, it is a low threshold. It's not new per se, it's that you haven't taken it from somewhere else wholesale. This, of course, ties into the rights of copyright against copying. Now, one misconception about copyright is that copyright can protect actual ideas. I'm not sure if you all saw the controversy recently with the Guyana TikTok alphabet videos, and a similar style video was made in Trinidad. The person who made the original video, they made the video about certain words in Guyana going through the alphabet in a school teacher's style. And then somebody did this in Trinidad, but using Trini words. There was a bit of controversy saying, the person in Trinidad copied the person in Guyana. Now, this is obviously true. The person did take the idea, as one might suggest. But you can't stop people from using your ideas via copyright. What you can't stop is how your ideas are, you can protect how your ideas are expressed. So if the person in Trinidad used the same words, as in he just repeated what was said wholesale with very little alteration, then yes, that would potentially be copyright infringement. But the mere concept of an idea cannot be protected by copyright. Protecting the concept of an idea is what patent law does. So patent law is really more applicable to people like inventors who are creating, for example, new concepts for the iPhone, or maybe not things that complicated, but things that are inventions that have not been done before, that can achieve some technical effect. Copyright protects what you have done and the way that you have done it, not the concept or the idea of what you have done. So people often think if they have this idea and they execute it, nobody else can do that idea because they've done it. So if you're a jewelry maker and your defining feature is that you make jewelry using local materials, so local seeds, and you have this style of jewelry, you can't stop people from using materials to make jewelry in that sense. You can't stop people from copying that idea. The jewelry design itself can potentially be protected, the specific design, but not this concept of using these natural materials. So there are limits on copyright, even though it extends to many things. It extends to the specific expression within the work rather than just the general concept of the work. Copyright can last for quite a long time. The length of time for which copyright exists depends, of course, on the country that you're in, but usually it lasts after the death of the author. So in many jurisdictions, copyright lasts up to 70 years after the death of the author. So again, the author being who created the work. So if you take a photograph, there's copyright in that photograph, that copyright is going to last up to 70 years after you die, depending on your country, which means your estate, your heirs, then will inherit that copyright, and the people will still have to continue to take a license, get permission to use that work even after you are gone. So copyright can have a very long-term value. Yes, correct, for some countries it's only 50 years. So it does depend on which country you are in. Copyright is also divided into two sets of rights. Yes, correct, Rod. Economic rights and moral rights. The economic rights are the ones that more of us would be familiar with. So things like the right against copying, namesake of copyright, the right to control things like rental agreements, lending, distribution, all things that relate to the actual copying of the work. But there are also so-called moral rights. Again, moral rights really depend on the country that you're in, which again really emphasizes why you need to be aware of the laws in the country that you are working in or the countries where your work is being commercialized. So there are key moral rights that I think are important for creatives. The first one is the right to integrity. So this really protects the heart and soul of your work. So this means your work should not be treated in a derogatory manner. The example here is that you sell your book to a publisher and they edit it without your permission. Now, maybe very minor edits would be okay. This would be probably also agreed to in any contract you have. But major edits that really change the actual story, change the nature of the characters, this is likely to be against your right to integrity. We also then have the right to attribution. So this is your right to have your name on a piece of work. And this right exists even if you don't own the copyright anymore. So you don't have control over the economic rights anymore, as in you don't actually have control to stop who's copying because you may have sold those rights. You still do have the right to be identified as the creator, but you have to assert this right. In other words, when you are disposing of your economic rights, you have to say, I want my right of attribution to be asserted. I want it to be known that I am the person who created this work. So that assertion, that saying, I want to continue to be associated with this work is very important in terms of making sure you can be identified as the creator of this work. Okay, so there are some myths on copyright that I thought would be cool to debunk. So we may have seen on YouTube this copyright infringement not intended phrase. This means nothing. This does not actually act as a defense to copyright. Just because you don't intend copyright infringement does not mean you have not actually infringed copyright. So putting that up as some kind of disclaimer does not have any legal effect in protecting you from being sued. We also have this concept of poor man's copyright, which I have actually fairly recently heard about. not know people do this, but apparently there is this misconception that if you put your work in a dated, sealed envelope, this somehow gives you greater copyright protection. This is not true. It doesn't prove that you didn't copy from somebody else. It doesn't give you greater protection than other people. And furthermore, it actually can work against you, because if you think somebody has copied your work and that's what you're claiming, having it in a sealed envelope inaccessible to anybody else is going to suggest that the person has created something independently. This independent creation is very key because, again, copyright protects this aspect of copying. If somebody coincidentally comes up with the same thing that you have come up with and they have not had any access to your work, so therefore they could not have consciously or even unconsciously copied, that mere coincidence is not protected by copyright. So again, it's not like patent law, the idea itself is not protected. So if somebody coincidentally comes up with the same thing and they have not been able to copy your work, they have not been exposed to it because it's in a sealed envelope that nobody could access, then your claim for copyright infringement is actually weakened. Another misconception is that when something is on the internet, it is free to use. So a few months ago, actually, Aaron Carter, who used to be a big star back in the day, Nick Carter's brother from Backstreet Boys, he used some artwork that he found online and got into a huge Twitter dispute with the artist. The artist, of course, said you cannot use this on your merchandise, as he was doing. Aaron Carter said, I can because it's on the internet. If it's on the internet, I can use it. That is not the case. Just because something is on the internet does not mean it is free to use. You will still have to take the relevant copyright license depending on what use you are making of it. So being on the internet does not mean you can just take somebody's work and do whatever you want with it. Okay, another misconception is that it's only copyright infringement if it takes place for generating profit. This is not true either. There is no for-profit requirement. You might be more likely to get sued if somebody thinks you're making money off their work, but this doesn't mean you are immunized from a copyright infringement claim just because you're not making money. So making money from somebody else's work is not a requirement before they tell you you're infringing my copyright. There is no for-profit requirement. I think these are some of the very common misconceptions that hopefully after today's seminar, we realize these are not really accurate descriptions of how copyright works. Now, within copyright, we also have performers' rights. Performers' rights are usually within the copyright legislation of different countries rather. On the international scene, they're actually considered separate, but in most jurisdictions, most countries, they will be within the Copyright Act itself. So performers' rights, as the name suggests, protects performers. Performers being people who act, sing, deliver, declaim, play in, interpret, improvise, otherwise perform. So performers, people who perform, as the name suggests. So who might be a performer? An actor, musicians, a comedian telling their jokes, spoken word artists giving their recitation, a dancer in a choreographed dance, and singers, people who are undertaking the act of performance. Now, performers' rights come within copyright. Another word you might hear in talking about performers' rights would be neighboring rights. It's called neighboring rights because they are related and very close to copyright. Performers' rights really have to do with the actual performance, as the name suggests. And it allows the person who is performing to either give permission to allow or deny the fixation of the performance. Fixation meaning recording, broadcasting and distribution of the performance, as well as making it available online. So if you are somebody performing something in, for example, a public event, you have certain rights to allow this to actually be recorded to allow that recording to be distributed, to allow it to be made available online. Now, often, when people are performing in a public event, there is this type of knowledge that it is going to be recorded, and technically speaking, you could object to that. If you have a contract, however, you will need to look at your terms. Of course, if you sign that contract, it is likely that you are giving the permission for it to be recorded, just because that's fairly standard nowadays. But it is worth being aware of the fact that you do have this right to prohibit such recording or dissemination, as the case may be. So I do have another video here that I'm going to play shortly. But in terms of the relationship between copyright and performers' rights, remember that performers' rights basically are within copyright. So if you have a performer's right to whatever your performance is, there is also going to be copyright in this work. So I'm going to share this video and we're going to see if we can identify the various works within the video. So allow me to just change screens.
College boy just say, ghostwriters, we so happy, happy people. Eh, eh. Oh gosh, nothing can feel good like this. Floating on the clouds, like if I don't have no problems, I feel so happy. It's only good vibes we bring that put me on the ceiling. I do love this feeling. It make me happy. If you wake up in a bad mood, I want you to shake it away. Some people want you to look good for yourself, but I'm better than that. Yeah, in this life, when negative vibe it comes your way, just ignore them, cover your ears and sing la la de la la de la de. Sing the happy song la la de. Everybody just come out la la de. Yeah, we can do it, nothing wrong la la de la la de la de la. Yeah. Cause I feel good like if I win the lottery. I know it. God, I feel so happy. Cause I feel good like if I win the lottery. I know it. God, I feel so happy, so happy.
All right, so I'm just going to put that on my slides. Okay, so we just had a performance shown.
You're pretty low again, Emma.
Oh, okay. Well, luckily that is the last video that I have to share. I think for some reason, sharing the videos.
Yes.
Audio. Let me just totally close off that screen on my side in case that is somehow affecting it. So just one moment. I'm just going to close off that screen completely. Okay, so let me put back up my slides. Hopefully this helps with the audio issue. All right, just pull back up the chat to keep on top of things. Okay, so interesting. I'm seeing somebody say sounds like he copied Marshall. Do you mean in terms of?
Yes, it's pretty low. You seeing that message there, Emma? You're still pretty low.
Okay.
I'm not sure what you did the last time to bring the volume up.
Last time I just put it on a book, but I think it might just be the fact that it takes a while to switch back. But I'm not going to play any more videos, so hopefully it gets back.
Okay.
I'm super close to the screen right now. I'm just trying to talk very close to the laptop. So interesting. I hear somebody say he sounds like he copied Marshall. Do you mean the style of singing? Do you mean the lyrics. That was Princess who made that comment. Okay, so keep in mind that copyright, as we just said, protects the actual expression of the concept. So it's not just the concept itself, it's how you did it. So somebody is free to imitate Marshall's themes, tunes, as long as it's not directly copied. Now, if it's a style of doing something, that style of doing something is not necessarily protected by copyright, because you can't protect just this way in which you do things. So we know Marshall has his distinctive sounds. It is very difficult to protect this distinctive sound under copyright. What could be protected is Marshall's lyrics, but again, the lyrics in the subsequent song would have to be very similar in the terms of words. We can imagine that soca has very, very similar themes throughout, right? It would be extremely difficult to say, for example, jump and wave. Somebody has that in a song and then somebody else has infringed that copyright because it's so commonplace. So again, the lyrics would have to be very similar to one of Marshall's songs for there to be actual claim of copyright infringement. So the style of singing is not something that can be protected, neither can the theme. The tune can be, but again, the similarity would have to be very, very close for any potential claim to succeed. And if it was that the tune is so close to Marshall's song that Marshall thinks, you know, this person has infringed my copyright, if he was actually to pursue it, he would have to be showing that, yes, it was extremely close in terms of the similarity. So it's not just enough to say that this person is somewhat similar, this person sounds inspired, or even that this person sounds like they might have done something similar. There has to be a high level of similarity for this to succeed. And you can imagine how contested something like that might be. So you want to have a really strong suspicion that copying took place, because the actual concept itself is not something that would be protected. So Marshall's style of singing or his words, unless the actual words are copied, that itself can't be protected. So within that video, we had the performance. College boy Jesse, who is the performer, will have his performer's rights, which means he would have had to agree to that recording of the song, which he would have done because that web series is based on this whole concept of recording and uploading these videos. But he would have had to, of course, agree to that because he has the rights to do so. Of course, within that video, we also have different copyright aspects. So we have the lyrics, we have the background music, the video as a whole. Even the set design can be something that is protected by copyright. We have the font for Lightbox that showed up, and even the Lightbox logo. So within that one video, we have all these aspects of copyright, and we have the performer's rights coming within that for College Boy Jesse's performance. Okay, so now we'll take some questions on copyright, and I know Charlie already has a question in the question box. So Charlie, in terms of your question, if Getty Images took that photo and is selling them, they should not be doing that because it is your photograph. You said you contacted them. What exactly is it that you said? Did you say that you are the copyright owner and that the website that they got it from did not have the permission to use those photographs? Because Getty Images is one that should have proper takedown procedures. So it might just be a matter of getting back to them, just pursuing them again and telling them, you know, if you don't take this down, I am going to pursue copyright infringement. just to clarify, Charlie's question is typed in the question and answer chat. I just want to make sure you all are actually seeing this, or else it seems as though I'm just talking randomly about something. You can all see this question. Okay, great, just making sure. Okay, so Charlie, what was their response? Because that's a very strange response. They are very clearly in the wrong there. I mean, there's no doubt about that. If you're the one who took those photographs. Okay, well, in that case, it sounds like you need to just keep on pursuing it and tell them that you are asserting your rights as the copyright owner, because they are clearly wrong there. There's no doubt about that. If you took those photographs, you are the copyright owner. Did they deny that you were the copyright owner? Okay, well then that's a very wrong situation, to be honest, Charlie, because you do have your copyright in those photos. What I wonder is maybe the reason they aren't taking it as seriously as they should is because in the US, to bring a claim for copyright infringement, you need to register your copyright. Now, you don't need to register for the copyright to exist, but to sue somebody for it, you need to have it registered in the US with the US Copyright Office. So I wonder if they're not taking it seriously because of that. But that doesn't mean, no, that response is in no way satisfactory, because you still, oh, okay, I'm now saying it is sent to all panelists only. So yes, everyone, please type into all panelists and attendees so everybody could see. So Charlie was just saying, and I'm now realizing I only seen this, that he needs to get in touch with the original site images were uploaded. I mean, you should do that as well, but that is incorrect. Just because they took it from another site doesn't mean that they are now immunized from copyright infringement. So I think it's a matter of telling them the facts, Charlie, because you could be dealing with somebody on the other side who does not really have proper knowledge, or is just being difficult to deal with because they don't think you're going to do anything about it. So it's a matter of making sure that you, well, before you do that, Charlie, I would make sure you go again and just tell them that, you know, you're serious. That is incorrect information they're telling you, because I can see your concern. But I would assert your rights again, because what they're telling you is that is incorrect.
Emma, do you mind if I interrupt you for a second? I believe persons are sending messages to the panelists only, so their messages are not showing in the chat at all, because it. So I want persons to just take a few seconds to go to the to section in the chat, select the drop down button and tick the line that says all panelists and attendees, unless you intentionally wants to send something to the panelists. You really want to be selecting all panelists and attendees.
Yes,
okay?
it's preferable if that setting is used, because if not, it makes it seem as though I'm just talking a bit randomly. So
yes,
please, any discussion, make sure it's selected all panelists and attendees so that everybody else can know what we're talking about, and I'm not just there talking to one person in this session.
Yes, that is correct, right?
Yes. Okay, so I'm seeing Natasha has a question. Let's see. Okay, so Natasha, when you say a lesson, are you talking about an educational lesson? If you're talking about an educational lesson, then most likely you would be able to use the defense of fair dealing or fair use, depending on where you are, that has an exception for educational lessons. Now, even within fair use, you don't necessarily get immunized from using an entire video, but for the most part, for educational purposes, it is allowed. So in a class, yes, you're probably likely to be fine, because copyright often does have these exceptions for using materials for educational use. Now, of course, this doesn't mean that you can photocopy a whole textbook and just share it. But in terms of things like using videos to illustrate a point or comment on it, that will allow you to Using them can come within one of the copyright defenses, which is fair dealing or fair use for educational purposes. So that type of use is usually permitted in a classroom setting. Yeah, and that's good to include the link as part of the acknowledgements. I think you're doing things correctly, Natasha. It's very unlikely that you would run into problems with that because of the setting that you are using it. Okay, and I see Keston has a question. All right, can you copyright melody? Okay, Keston, so it is possible, but because certain use of melodies tend to become a little, I don't want to say commonplace, but they become nearly part of music in general. It would have to be something very distinctive. And the fact that somebody's using a different key, because it's a melody, could be enough to differentiate it. Now, when we have things like that, that somebody's using something very similar but in a different key, those kind of things often do end up in a very heated dispute where the person's saying, well, it's a different key, so it's not the same thing. And the person who created the original melody is saying, well, yes, it's not exactly the same, but it is basically copying for the most part. That does get very heavily disputed. You could try to tell the person that you are asserting your copyright in this, but because of the variation, as well as the fact different lyrics are used, it is not a straightforward clear-cut infringement. If that was to go to court, there would be quite a battle on both sides, and it would really be a judgment call at the end of the day. So it's not to say it's a straightforward thing. What you could do is tell the person that you have created this melody, so one small variation is going to infringe your copyright, but this doesn't necessarily mean that they're going to back down on it because it is somewhat different. If it was the same thing, then yes, that is fairly clear-cut, but this whole slight difference is what causes the confusion there.
There are a couple of questions. I don't know if we missed them, Emma. One from Lisan that speaks to some songs that he wrote that his ex-wife now sings. Is that his copyright or
Okay,
not?
I think that is in the chat. Okay, so question there is, I wrote several songs that my ex-wife sang. Does the copyright then remain with me? Well, Lizanne, I'm not sure if you had any kind of written agreement with your now ex-wife. I'm guessing maybe not, but if you wrote the lyrics for those songs and you had no agreement otherwise saying that the copyright is being transferred, then yes, you would have the copyright for those lyrics.
Okay.
And I see continuing on from
Yes.
that.
Yes, yes, as a continuation of that first bit there.
Right, so Lizanne saying, I wrote a song that another artist then fleshed out and refined the melody to. She then listed the song as being written by her, but who actually owns the copyright there? Well, Lizanne, if you wrote a key part of the lyrics and then the person then contributed to it, you would both be the owners to that. That's like to be a joint work. So you should be included as one of the creators for that song, because it sounds like from what you're telling me, you have done quite a lot of groundwork for that song.
Okay, so he says no written agreement there, and thanks for that. And then Inette has a question there as well.
Okay, and I see Raul also has a question in the Q&A, so I answered that as well.
Yeah.
Okay, so if you paid someone to change original work from one format to another, such as a short story to a movie script, who owns the copyright to the script? Okay, so changing a short story to a movie script. All right, and so the person who created the script is going to have copyright in that, because even when a speech is spoken out, if somebody writes it down, that person is going to have copyright ownership. And I know what you're thinking, that seems very unfair. But because the way copyright works, the person who is doing that transmission in your case will have ownership over the script, which is why it's very important that you, I don't know if this has already happened, but that you have a contract saying that that person is not going to have the copyright ownership, you're going to have exclusive ownership. Okay, if you've hired them to do that work, it depends which country you are in. So for example, in Trinidad, there's no works for hire provision. Now, such ownership can be implied, but in the absence of local law in the country that you're in, with a works for hire provision meaning that the person who is paid does not own the copyright. In the absence of that, you do need an agreement saying that you actually own the copyright. So if there's no provision in whichever country you are in, you just need an written assignment from the person saying, I transfer this copyright to Edith. So that's very key, everyone. If you're paying somebody to do work for you, you are probably going to want to get the copyright assignment. So interesting to note, in a very everyday situation, when you hire a wedding photographer, if there is no works for hire provision in your country, your wedding photographer can own your copyright in your wedding photos. And for example, in Trinidad, they will charge an assignment fee, in other words, a fee for them to give you the copyright to your wedding photos. So this applies in fact everyday settings as well. And I see Raul has a question in the question box. If I direct
just before you take that one, I just want to say thank you, Lisanne, for that clarification. I see your note. Thank you.
Okay, so if I directed and edit a music video from 2010, what are the process to claim rights? Is there a limitation to what I can receive from the missing years to the current date? I would lock down the official rights. This is a real circumstance. Otherwise, I have received royalties for various other works. So a few to sort out as well. I create a lot. All right, Raul, so yes, if you direct and edited that music video, in terms of claiming the rights, it depends on who is currently commercializing this video and whether you would have actually maybe signed away those rights in any contract. So if you had a contract that stated that actually you don't have any copyright ownership, in that case, you won't be able to claim those royalties. If your contract does not say that, then you will have some type of ownership in that video, and it would be a matter of contacting whoever is now exploiting that video, whoever is now making the money from that video to actually, okay, so if there'd be no buyout of rights, then you have to contact whoever is in control of that video, and then tell them I had this role in this video and I have not received any royalties, and you'll have to work that out with them. There is no limitation in that sense because your copyright has not expired. So it is a matter of contacting them and telling them the situation, explaining that you have not gotten your royalties from this video. Okay, well, particularly if it's distributing worldwide in territories, it is definitely worth contacting them. If it is that you didn't make it with them, though, I'm pretty sure they're going to want to know what agreement was made between you and the person who was in charge of the video, as the case may be, in terms of what editing role you had. So, yeah, so it's a matter of following up, explaining the full situation. And in many of these cases or circumstances, it is a matter of clarifying what exactly happened. And this is why I said at the beginning, and this is something to remember going forward, it's very important to be proactive when you are creating copyright works, when you're dealing with other people. Having good contracts in place can save you a lot of trouble down the road. All right, so thank you everyone for the copyright questions. We will now move on to trademarks. Now, copyright was the most intense part of the session. The other rights we're looking at don't worry, they're not as intense, not as long, and some would suggest also easier to understand. So we will go through with this, and then we will have a short break soon. I'm sure you're all ready to take a break in a short while. So trademarks. Do you all recognize any of these brands? These are well-known regional brands that are likely to have registered trademarks. We have previously talked about this use of the R and the TM. The R is for registered trademarks. The TM is for unregistered. Trademark law is also territorial, as in, if you want a trademark in Barbados, Guyana, St. Lucia, and Trinidad, you have to register that mark in each of those countries. You can't just register it in one, then expect that it's protected in all. You still need to go through the registration process. If you do not register and you have an unregistered trademark, there is a level of protection, but to really have this protection, which is known as passing off, you have to have customers in the territory where you claim your trademark is being used without your permission for it to work. Now keep in mind, we just talked about copyright and how copyright can apply to artistic works. So all these symbols on the screen would be subject to copyright protection in addition to the trademark protection. Copyright protection means that they cannot be copied, the actual art. The trademark protection means that they cannot be attached to other goods and services without permission. Because doing so would cause confusion. It would make people who are purchasers think that, oh, okay, Digicel is being attached to another phone service. This must just be an extension of their brand. So key thing to remember here is that if you are dealing with a trademark work, you're probably going to have copyright in the actual art, and then potential trademark rights, either registered or unregistered, depending on which route you take. Just because you have a logo doesn't mean you have a trademark. The registration process is very important. If it's not registered, then you do need to have customers in the territory to be able to avail of unregistered trademark law. Okay, now as I said, unregistered trademark law can work. It's called passing off, but it's a lot more difficult to successfully claim under. If you have a registered trademark, then you have a clear point of reference saying this mark is registered for these goods and services. This person has been using this mark on similar goods and services. This is going to cause confusion. I have a claim. Without the registered trademark, it has to be more than confusion. People have to actually believe that there's some unauthorized connection here, or rather, they believe the connection is authorized, but you did not authorize it. So registering makes life easier in terms of protecting your logo or your brand, as the case may be. And in fact, it's also a worthwhile process, because if you apply to register and you are rejected because somebody else has opposed your registration, that basis for opposal is likely to be the existence of a similar mark for similar goods and services. Which means if somebody successfully opposed your mark, you might be at risk of infringing an existing mark. So if you do go down the trademark registration route and you get rejected, the reasons for rejected are likely to be listed by Intellectual Property Office, and it does raise a red flag for you. So it might be disappointing, but actually it is a good warning so that you're aware of the potential for infringement on your part. The other benefit of registering, in addition to having this evidence, is to fully outline your rights. So trademarks can be registered for categories of goods and services. It's not that you just register a trademark and that mark cannot be used on anything ever by anyone. It's registered for certain goods and services. So for example, let's say you register a mark for use on merchandising, clothing, soaps, and food stuff. Those are the goods and services for which there is protection. So it outlines your scope of protection. It also provides you an asset that you can license to somebody else or even assign in the long run. So assign means you're getting rid of your right, you're giving it to somebody else. For example, you're now selling your brand completely to somebody else. You decided you're going to retire. You can assign it. Or if you want to still be actively involved, you can potentially license it. So you might enter into a partnership with someone. Your brand is already valuable. They want to use your brand. So you can issue a license that they then have to pay for to use your brand. So it does provide an asset which you can work with. And if you have this proof of registration, it makes the other party more confident that you have clear rights. Whereas if you don't have it registered, you may have rights under passing off, but these rights aren't as clearly defined. Okay, so debunking some trademark myths. Just because you have a trademark doesn't mean you can stop people from actually talking about the mark or putting it in a music video or something like that. Now, copyright might be an issue, but in terms of speaking about the mark, you can't stop them from just talking about it. So people can't talk about your mark. What the trademark prevents is confusing use in the course of trade. That being said, comparative advertising is allowed, but confusing use where people are seeing this mark and thinking, oh, this must be a connection here, that is not allowed. But it's not a blanket that stops everyone from using this mark in any context and not speaking about it. So going on to the second one, it's not that they can't use it on anything. There has to be this issue of confusing. The only time that the confusion aspect is not required is if you have a very world famous mark. But when we're talking world famous, we're talking like Coca-Cola, Apple, Disney. Those types of marks that are internationally famous have special requirements, but those are based on the fact that everybody knows them. So obviously you wouldn't now be allowed to go and make Apple computers because those are so well known that they have their own special provisions. Unless your mark is internationally famous, their use by somebody else has to be confusing. This confusion is going to be assessed by the similarity of the marks, so it doesn't have to be a carbon copy, but it has to be similar, as well as the similarity of goods and services. We then also have the issue of this registered versus unregistered. So as I said, you do not have to register a mark to get protection, but it is better, stronger protection, clearer protection. That being said, the law of unregistered trademarks passing off does exist, but to bring a successful claim there, people have to be deceived into thinking that there's a connection. So not merely confused thinking, oh, is there a connection? They have to think, oh, there's definitely a connection here. And as you can tell, that makes it a harder area of law to claim under. So registration is very helpful, although not required to get protection. Okay, so as you can see, the trademark section was a lot shorter than the copyright section. Do we have questions on trademarks? Sure. Okay, what are the categories of trademarking? So there are 41 categories, 41.2 categories, I don't remember the exact number, that are used internationally under an international classification system. And within those categories, there will be hundreds of goods and services listed. So you'll have a general category, for example, food stuff. And within that, you'll have things like bread, chocolate, cheese, ketchup, mayonnaise, all the different foods listed. So there's loads of items under each of the 42 categories of goods and services. Okay, so trademarks fairly straightforward, especially compared to copyright. All right, persona rights. Persona rights is actually my favorite area. It's the area in which I focused on for my PhD. And it's really about protecting your personal features from unauthorized commercialization. All right, so Feline is saying registering a trademark in each location sounds expensive and time consuming. Is there no one place to register in the world? So Feline, unfortunately, it is expensive and it is time consuming. In some areas of the world, for example, the EU, there is a centralized EU intellectual property office where you can register for several European countries at the same time. In other places, you just have to go to the individual country and register unless they're part of something called the Madrid Protocol. Coincidentally, Trinidad assented to the Madrid Protocol maybe a few weeks ago. This means that any country that is part of the Madrid Protocol, you can go into your intellectual property office, file your trademark, then you'll still have to pay other fees, but you don't have to go through the lengthy application process all over again. It kind of centralizes it. It doesn't guarantee acceptance in each place because it still has to be assessed, but it makes it a lot easier. Unfortunately, many Caribbean countries are not part of this protocol as yet, and it does mean that if you were to register in every single Caribbean country, you'll be looking at thousands of dollars. So yes, Jamaica is part of it as well, and that makes it a lot easier. What kind of lifespan does a registered trademark have? Generally speaking, a registered trademark can technically go on forever because you get an initial 5 or 10 year registration depending on your country, but that can keep on being renewed. So you can keep on renewing it, and once you keep your registration up, it can go on indefinitely. So it depends on if you keep your registration going. Is there a CARICOM trademark bubble? No, unfortunately there is not. That's something that would be extremely useful, Alberta, but it does not exist as yet. In fact, having one CARICOM intellectual property office to centralize these kind of things would be very helpful, but we are not at that stage right now. Okay, so persona rights. So we have some photos on this slide of different personalities, and they're obviously advertising different products. Now, why would these people care about how their photos are used? They're going to care because they are going to make money off the use of their images, right? Which means if people start using their images without permission, they're losing out on potential revenue. So this is an area of law that's actually very well developed in the US, less so in the UK. And as for the Caribbean region, do we have these rights? Well, technically there's only been one case. It was a Jamaican case involving Bob Marley's estate and t-shirts being made with a picture of Bob Marley's face. That case suggested that both unregistered trademark law, known as passing off, as well as the tort of appropriation of personality could be used. So passing off was just previously mentioned in relation to trademarks, so it is unregistered trademark law. To succeed on this as an individual, you need to again have customers in the territory where you're making the claim, and people have to believe that you would have actually endorsed this use of your persona. So Olivia, there is actually a website, the World Intellectual Property Organization, which I talk about at the end. They have a repository of laws for different Caribbean countries. So it's very handy actually. So thank you for bringing that up, and I will come back to that at the end of the session. So passing off can be difficult to claim under, but the tort of appropriation of personality is actually very easy. You don't have to prove this confusion aspect. You just have to prove that somebody used your persona in a commercial setting without your permission. Now, because this area of law has not really been tested throughout the region, there is a question as to how different courts in different countries might rule. But just because it hasn't been fully tested does not mean it's not valuable. It is very worthwhile protecting your persona and pursuing unauthorized uses of your persona to make sure that you are preserving the value. So if somebody is using your face to advertise something and you didn't get permission for that, it is worth saying, hey, I am asserting my persona rights. I did not give you permission to use my face in this commercial setting, keyword being commercial. And of course, the more famous a person gets, the more valuable their image becomes. And you want to make sure that you're enforcing this value, because if you're not, people just start using your image everywhere. then you're going to attract potentially less money for those who are actually willing to pay. So you do want to be protecting your image. Now, in terms of persona rights, yes, you can protect your image in commercial settings, image being yourself, but it doesn't mean you can just stop anybody from posting your photograph anyway. And also, depending on where you are, there is potential need for this deception. So yeah, it is kind of like trademarking yourself, Alberta, because you are trying to protect yourself, like you as a person. All right, so Bradley, you actually bring me to the third misconception on this slide. Just because you're in a photograph doesn't mean you as the subject own the photograph. The photographer is the copyright owner. And since 2017 to present, at least 30 celebrities have been sued in the US for posting photographs to their Instagram accounts. The photographer is the person who owns the copyright in that image. You don't own the actual image. You can prevent somebody else from using that image in a commercial setting, but the photographer remains the copyright owner of that image. So Bradley, that is a very common misconception, and I can imagine you get a lot of pushback there, but the photographer is still the copyright owner of the photo. Another misconception is you can stop people from talking about you or saying your name in a song. This is not true. If somebody's harming your reputation, you might have a claim in defamation, but it's not exactly a straightforward thing where just because somebody talks about you, you have a claim. It's not automatic. Right, if your image is used to defame you, then defamation could come into play, but for defamation to succeed, Sonia, you have to show that your reputation really is being damaged by this use. All right, so what is commercial setting? If someone has a personal Twitter account that has many followers. So Alberta, it depends on what exactly they're using the Twitter for. One could suggest that celebrity Instagram accounts, even though they're so-called personal, they're essentially doing that as part of their business. Now, if somebody is just really having a normal Twitter, it's a normal person, even though they have lots of followers, that's not necessarily going to be considered commercial unless they're using it to actually sell things, to promote products and stuff like that. If it's really just a Twitter account, the person's popular, but there's no commercial activity taking place, no selling taking place, then it's not going to be considered strictly commercial. Well, Bradley, I have no doubt that you've experienced this because there's lots of misconception. Look at the problem Charlie was having with even a site like Getty Images, which definitely know better. There is a lot of confusion around intellectual property, a lot of misinformation that is spread. Okay, so I am aware of the time, so let us take a 10-minute break before we go on to design rights, as we've been talking about the questions about persona now. So let us take a 10-minute break and meet back here at, is my watch correct? At 10 to the hour, because I know we're in different time zones. Okay, so I will type in the chat when we are resuming, just so everybody knows. And I will also turn off my camera for now, as I'm just going to step away to get some water. So we will resume in 10 minutes. Yes, that's correct, Alberta. If you are having this type of affiliate marketing, you do need to be very careful with what exactly you are posting. And people like influencers who may come into that type of field without previous maybe intention to even do so, you can have some serious issues there. Yes, Haral, you sound like you've had a lot of intellectual property issues, but it's good that you are trying to pursue your rights. All right, so just give me a few minutes and we all take a bit of a break here. Okay, so let us resume. Hopefully everyone had a nice break and is ready to get back into this. So we had just spoken about persona rights. Are there any questions on that? Protecting your persona rights is really a matter of having good contracts. If you are allowing people to use your name, your voice, your likeness in advertising, on merchandising, and also pursuing uses that you haven't authorized. So if you see a company using a photograph of you and you didn't authorize that, you should be telling them, I did not allow this, I am the person in this photograph. Because what will happen is that they may have gotten the copyright license, which makes them think they can use the photograph, but copyright is one level of rights. If you are in the photograph, you can still also say, well, I want to be compensated for this. Now, this being said, because the law is not really fully fleshed out within the region, they may or may not respond. If you are somebody who has some clout, as in you are a well-known personality, they are more likely to respond. If you are just an ordinary citizen, they may respond, but realistically, what you will get is a so-called lost license fee, which is how much they would have otherwise paid you. It's not going to be that much. Sometimes they might just say, okay, well, we'll pay you off to allow us to use this, to allow us to use you in the ad, because they might not want to redo the ad. So the rights are not fully fleshed out, but it is worth still trying to pursue any unauthorized uses, because it is something people are becoming more aware of in the region, and something particularly for those who are well-known people, you want your image to have value. So still worth pursuing. Do we have questions on persona rights? Okay, so industrial design rights, also just known as design rights, not a very popular area of IP. Industrial design rights really protects the appearance of a product. So examples usually given in this type of legislation. Okay, so good question, Alberta. You don't actually apply for persona rights. Good question. Unlike the registered trademark application, there's no application process for persona rights. This is something that just exists. Whether it exists in your country depends on the view that the courts may one day take. So again, it's not fully fleshed out, but because we have had a case in the region, it is possible that the so-called tort of appropriation of personality can be applied. Even if it doesn't, unregistered trademark law can be used, but neither of those have registration processes or require registration. So even though the kind of protection you're getting in Alberta is kind of like trademarking yourself, there's no similar registration process. No problem. So industrial design rights protect the appearance of products. Now, in the past, this has been used with things like unusual furniture designs, speaker designs, and the important thing to remember is it protects the visually pleasing aspect. So it cannot be that you're trying to protect the functionality of an object. You cannot get protection for that. What you can get is protection for the appearance that is visually pleasing and unusual. It has to be that there's something special about this. Now, this does require registration, and again, it applies to the visually appealing aspect of a functional item. So you cannot protect anything that is required for it to function. So if, for example, you're registering a chair with 4 legs, that in itself is not registrable. It has to be that there's something interesting about the chair. Maybe the backrest has certain swirls incorporated into it, something like that. But it can't be that you need that aspect for the product to work, because the functionality of the product is not protected. It is the appearance that is being protected. And industrial design rights, you have to have a new concept. So unlike copyright, where originality is used differently, new in this sense really means new, as in you haven't disclosed it before, you haven't shown it to anybody. Most countries do have a set period of time after display that allows you to file, sometimes up to a year. So you might have shown it at trade shows, for example. But this whole new is very important, as in it really has to be something very unique that you're trying to register. And because of this harsh requirement, or maybe onerous is a more simple word, they aren't that popular, because most people will, move on to something else after a while. They won't place as much value on that specific design, for example. And also, registration process can be very time consuming. It can take up to a year. Not that you can't use them that time, you can, but sometimes people just don't see them as very valuable. Now, in terms of who might find them valuable, they tend to be used more recently by jewelry designers, fashion designers. And the reason you would use this instead of perhaps copyright is because things like jewelry and fashion do not strictly fall within copyright. In some countries, there have been heated debates in the courts as to whether they should, but for the most part, they are not clearly within copyright. What would clearly be within copyright would be the sketch for the jewelry, the sketch for the design, or even maybe paintings on a fabric, for example. But the actual jewelry, the actual piece of clothing, is not always clearly protected by copyright, which is why sometimes the people who are making very unique things do go for industrial design rights. And I believe there is somebody in Jamaica who has an industrial design right on one of her jewelry designs. So if you're trying to make something really exclusive, then yes, you might want to go through the industrial design right process through your intellectual property office, but you would consider whether you think this is a good use of your time. If it is, you're going to move on. This is just one pattern, you're going to move on. Subsequently, it might not be worth it to you. So it really depends on how valuable you think the exclusivity is for your product in your business. Okay, so industrial design rights, again, not often used, potential for use, particularly if you are perhaps a jewelry designer or fashion designer, mainly because of limitations on copyright, but not many people opt to use them. Do we have any questions on industrial design rights? Okay, so what is the process? Just help people protect you from the bootleg black market. All right, so in terms of the process role, it is a matter of filing the concept of the design with the intellectual property office. Each intellectual property office in each country is going to have a different perhaps system. Some might do it online, some might have paper forms, and they will require information about what the design is, if there's any specific colors, shapes, basically the full design, and usually they'll also require a sketch or photographs that identifies it. They then, example, a 3D character, three-dimensional toy or statue, all those things, they require full description, graphic representations of what this thing is, and then they go and do a search. The search can take quite a long time, because remember, it has to be new in the sense that it has not been exposed anywhere else. So the intellectual property office will have people who are designated searchers. They will determine whether your submission is actually considered new. If it is considered new, then you can get the protection. But as you can imagine, this does take quite a while. So if you are doing something really cool, like a new shoe design that you want protected, then what you should be doing is filing very early so they can get this process rolling. Okay, and does it help protect people from the black market? Well, Yola, technically it should, but the problem with black market and bootleg products is that the creators of these products are often very difficult to track down. And this applies to black market anything. The people who create black market or bootleg products tend to operate very clandestinely. So even if you have your rights, if the entity is not really a well-established entity, you can pursue them because you have this right, but most likely they will disappear. it's a straw man situation where they probably know that they're doing something wrong, so they make it so that it's very difficult to track who the actual infringer is. They might disappear and then pop up under a different name. So yes, in a perfect world, it should help, but realistically, and this goes with intellectual property in general, it is a lot easier to pursue the more regulated entities that take on the law and that can be identified. So yes, it theoretically should help, but it's not always that easy to track down those bootleg or black market producers, unfortunately. That doesn't mean you can't, you can. It's just not always easy. Yeah, they may indeed be making big profits, but what many of them might be doing is using offshore companies, using websites, using all kinds of stuff. So again, it's not that you can't, it's just that they tend to skirt around the law. The law still applies to them, but they can be a bit difficult to actually track down. Not that you shouldn't. If you have resources, you should pursue them. But a normal regulated entity should be responding favorably to a letter. Unfortunately, this is not what Charlie has experienced, but they should be. Whereas those entities tend to not care as much, they will ignore you as far as possible. Again, that doesn't mean you can't do anything about it, it's just you might be in for a bit of a fight. Okay, so now we have covered the first topic, and I know what you're thinking, how you've already done one. That was really the bulk, because now that we understand the rights, we can start to understand what we can do with these rights. So it was very important to outline these rights, get a basic understanding, so we then can go on to what we can actually do with these rights. So we've been talking a lot about the different rights. Why are these rights actually important to you as a creative, or whatever your background might be in this session? All right, so Raul said he's actually going to be using all the rights, which is really cool. So in terms of using these rights, now obviously you can be protecting your intangible assets, because in some cases, for example, things like copyright, you can't necessarily touch what you are protecting. So there is this value in protecting something that is not tangible. For example, your brand value, you can't necessarily touch it. You might have products to which it's related, but you're protecting this concept surrounding it. By protecting this, you are strengthening your brand, strengthening the value behind it. It's also important to be aware of all this because you want to avoid potential claims. So you might be aware of your rights, but of course you have to be aware of the rights of others. You don't want your business, your hard-earned money being spent on fighting off other people, saying that you infringe their copyright or their design rights or anything like that. You want to make sure you're doing things by the book insofar as possible, because you don't want to take your hard-earned money and then have to pay that out to somebody. Because even if you don't reach court, even to avoid reaching court, there might be money needed to be paid. So you want to avoid getting yourself into hot water in the same way you don't want to, you don't want other people infringing your rights, you don't want to infringe their rights either. So also building this brand can go beyond your actual product. So let's say you have your product is jewelry. You have your product, you have this brand, and you become very well known for a very luxurious but natural, organic style of jewelry. And when people hear your brand, they think, oh wow, like they associate, a nice lifestyle with it. They associate relaxation. They associate cocktails on the beach. All those kind of images pop up in their head when they hear your brand. That is creating value in your brand that you want to protect. And when you protect that, you can then license that because people want to be associated with your brand. So it goes beyond the actual product to this feeling that you're protecting. And again, even though you can't protect ideas per se, this feeling can be protected within the brand, within your copyright, even within your persona and your design rights. And by entering into licensing deals, you can then have more money coming in. So it's very important that you're laying the groundwork to generate this revenue. You might also want to be get investments one day, and investors really like a clear IP strategy because it tells them that you are serious. It tells them that you have a plan, and it also tells them that there's some type of asset being protected here, whether it is your intangible or even your tangible. So it gives people confidence that you are, taking the right steps to really ensure that not only your revenue, but their investment is going to be protected, because it really just makes it seem more professional even. And then of course, you can even go bigger than partnerships and go into franchising. Companies like KFC, for example, I mean, who doesn't know KFC, right? KFC operates on a franchise model, so they will have certain processes that people have to follow, but people have to pay a lot of money to get in on that franchise. Even CrossFit. CrossFit is an American brand, I believe, and I know we don't necessarily have CrossFit classes in all the regions here, but to get yourself as a CrossFit trainer to get authorization to do that, you have to be going to the original brand holder. So you can have a very far reach if you really do the protection from the outset, and you can get to the point where you have a franchise packet and people pay you a lot of money to get into your franchise. So rather than just working with one person, you have your package that you are selling to others. You will monitor the quality, but it does let you be a bit hands-off because you're selling this valuable brand, this valuable information, valuable product knowledge to somebody who wants to buy in to this whole concept, this whole idea that you are selling. So there is a lot to be said for having a good IP strategy and for making sure that, of course, you're not infringing on others' intellectual property rights. So this here is the IP onion. By IP onion, I mean that there are different layers to your intellectual property. Your primary layer is your product. So this is pulling in what we talked about before. You have your product, right? But then you have a story around the product. So you sell it, you are using different photographs, for example, so you have your copyright there. You're using maybe songs to promote it, you have more copyright there. You're building this whole concept. So you're not just selling a product, you're selling an experience. This experience is then being encapsulated overall by your brand. So whatever your brand is, your trademark, even slogans that you try to get trademarks, so logo slogans, this is going to encapsulate everything. So it comes to the point where if you've really expanded properly, you've taken all the steps to do your marketing, which I'm sure you have learned about in previous Patchwork sessions, and you have your IP in place, your IP takes you beyond just your product to your story, to an overall brand that becomes very valuable in the eyes of consumers. People then start associating certain values with your brand because they know your story. And in fact, even if they don't know what your product exactly is, they don't know your original product, they have this association with your brand because they recall, I remember this advertising campaign, and I remember the name of the brand. The brand really stood out to me. They get this association, even if they can't remember what your product is. And maybe when they enter the market and they say, okay, I need this product, I see this brand is selling this product. I don't remember what else the brand sold, but I remember that brand. So it is about trying to protect all your various assets to create this onion, to create these various levels of protection. So you take it just beyond just your product to your overall brand process. By using the rights we have already discussed, you are able to build these layers of protection. Okay, so important questions now. How do I actually protect and commercialize? So we talked about all these different rights. How can we actually use these rights now? Now, first thing to note is that suing is very rarely the answer. And I know I've already said this before, but I want to emphasize this because what tends to happen is something goes wrong, people get very angry, and you can see why intellectual property tends to be quite personal. People get angry and automatically want to sue the other person until they realize that actually a lawyer is very expensive, court fees are very expensive. If you lose, that's really expensive. Even if you win in some countries, that can be expensive. And at the end of the process, unless you have a lot of money behind you, you can come out with less than you went in before. So this actually applies to all areas of law, not just intellectual property, but we're focusing on intellectual property today. So court is very rarely your first port of call because of the expense and the length of time it can take to get a case through court. So what you want to try to be doing is taking practical steps and considering court as a last resort option. So there are different steps you take. If you have registrable IP, you register it. So if you have a trademark, as I said, registration is not required, but it's desirable, so it is worth registering. Similarly, if you are trying to protect the visually pleasing aspect of a product, you can register that as an industrial design right. You also want to assess the marketplace. So what else is out there? Are you dealing with a product that has often been created? Are you dealing with something that is very popular? In which case, how are you standing out? Standing out obviously ties into your brand building and the story behind your brand. And then of course, have proper contracts. Now this is key. And we're going to go a bit more into this, as well as clearing the rights and as to what that means. Now, I just want to talk about registration first before we talk about this contract issue. This table shows you the different rights and whether you need to register. So copyright does not need to be registered, generally speaking, except if you want to sue in the US. So when I was talking about Charlie's problem with getting images, I was saying that maybe they're not taking it as seriously because it's not registered in the US. Now, you don't have to register for it to exist, as you still have the copyrights, you don't have to register, but to sue and get money in the US, then you need to register. So that is something worth considering. The next issue is trademarks. Again, you do not have to register a trademark because there is the law of passing off unregistered trademarks, but registration has definite advantages because it makes it clear as to what your rights are. If you want to do that, you can file in all the relevant countries, or if your country is part of the Madrid Protocol, that makes the process a lot easier because it allows you to access other countries that are part of this protocol. And yes, that information is available online through one of the organizations that we will talk about in the end. Something to note is that many countries do require the filing to be done by a lawyer or an agent, but not all of them, as in your country. Somebody had already asked about persona rights as to whether you have to register them. No, you do not have to register, so there is no registration system. Design rights, you do have to register, and you will have to file in the relevant countries. So remember, when we talk about registration, those that have to be registered, the territorial nature of intellectual property becomes quite key. Okay, so I'm seeing a question in the question chat. Let's see. Situation where someone works for a company, the person is part of a creative team. How does IP guide the interaction between the owner and the creative team members in terms of what both groups can and cannot do around the creative product or service? Okay, so usually, Alberta, if somebody is working in a company as part of a creative team, there will be a contract of employment. Generally speaking, when you are on a contract of employment, as in you are employed by this company on a regular basis, you're not just a one-off contractor, there will be ownership issues there. Ownership will usually belong to the company. And again, this really depends on the legislation of each country, but generally speaking, there is this employment provision where employees, the works done in the course of their employment will be owned by the company. So the company in that case becomes the first owner. And additionally, your contract may speak to that as well. If the company has well-drafted contracts, they are likely to say that anybody on the creative team gives up all their IP rights, their rights belong to the company. So usually for employees, unlike independent contractors, there is legislation saying the company owns it, or even it's in your contract. But you still, of course, need to check whichever country you are in because there can be some variations on that. Okay, so it's very important to understand whether you have to register or not, and if you think registration is worthwhile, it is something that should be pursued, something that can take quite a lot of time. All right, so we're back to this contracts point. People tend to not like contracts. They don't like it because it seems very formal. They think, I am working with somebody I know, this person wouldn't do that, like, good, so I'm not going to use a contract. And you can see why people feel defensive if you suggest a contract. They say, you know, we've worked together before, you want a contract now, like, it seems like you're questioning the relationship. However, this mindset around contracts really needs to change, and you might meet opposition initially, but having a contract can make things so much easier in the long run, because when you run into a dispute, you can refer to your contract. So having a well-drafted contract with all your key terms, outlining things like ownership, payment schedules, how you want to commercialize it, any restrictions, having all of that in a contract just makes life a lot easier. So you don't want just a contract, you want a well-drafted contract that thinks of all the possible problems that might be arising. So once you have that in place, if a problem does arise, you can just refer to the contract, and usually that will help solve it. If the problem is not specifically addressed by the contract, it is likely that there will be some kind of relevant communication within that contract that will still be useful. The problem is when there is no contract in place and people are relying on things like WhatsApp conversations or just word of mouth, there's often a kind of he said, she said problem where people have very different thoughts on what actually occurred. This is where disputes come about, and then you're referring back to maybe multiple emails with different ideas being exchanged, and it just makes it a lot more difficult. So even though people are not necessarily fans of contracts, it can help you in the long run. So even if it's your friend, in fact, if it's your friend, just tell them, you know, this is really, we won't actually need to use it if it all goes well, and if it doesn't go well, it helps both of you. It's not a one-sided thing. So Veril is saying he's had issues with this, with taking somebody's word. I think most people may have had issues with this, Veril, because it happens, you know, it's just part of life. If we have it written down and we have a well-drafted contract, it just makes things a lot easier with that point of reference. Because often, remember I talked about being proactive, often people are reactive, so they will seek advice when something has already gone wrong. And sometimes a problem, if it's a relationship problem with somebody you're working with, maybe you could have avoided it to start with. So contracts, very important, properly drafted contracts that really consider any kind of potential uses of the product, what the product is, ownership, payment schedules, royalties, licensing agreements. Obviously the nature of the contract depends on what you're doing, but just having a contract can make things a lot more straightforward in the long run. Okay, so I also mentioned this whole clearing the rights before. Clearing the rights basically means that you are checking whether you can actually use these rights, whether you are contacting the correct person to use these rights. So copyright, as you can imagine, based on what we discussed, can be somewhat more difficult than the other rights. So copyright, as we mentioned, does not require registration unless you want to sue for money in the US. So if you want to make sure that you're in the clear with copyright, you need to think, where did I get this material from? And remember, just getting it from online does not automatically mean you can use it. Can you tell from that online file who the owner of the copyright is? Remember, the first owner is often the creator, but that person might have subsequently sold those rights to somebody else. How many aspects are subject to copyright? So we looked at 2 videos. We saw that there's loads of different copyright works within even just those 2 videos. Did I actually get permission to use whatever I am using? So did I get a license giving me permission? Or did I get an assignment? Did I buy out the rights that I can use it? And are there any limits? As in, even within that license, that permission, there may be some limits on what you can do. So asking all these questions up front really lets you know whether you are approaching copyright correctly. Of course, there are some copyright offenses. For example, somebody had already asked about educational setting. That is under fair use or fair dealing. Fair use or fair dealing also covers things like criticism and review. And again, depends on your country. But if you're in a strictly commercial setting, you do want to be very careful about how you're using any kind of right, actually, especially copyright in this case, because a commercial setting is way less likely to have these offenses applying. Now, the other ones can be a lot easier. So trademark, if the person is the registered trademark owner, they'll have a certificate. So that's straightforward. You don't have to go through this all roundabout process because that certificate should say who the owner is. In terms of persona rights, it's usually the individual, but some individuals might put their rights into a company. Either way, by getting in touch with that individual or the individual's management team, you should be able to tell who exactly you're meant to be contacting about using this individual's persona in whatever way you're trying to use it. Then, of course, register the design right. Because, again, there's this registration process, there will be some kind of certificate. What type of company do people vest their persona rights in Alberta? You can just do a normal limited liability company. And the reason people do that is usually to kind of administer the rights to this company and avoid any kind of personal liability in certain situations. Often other jurisdictions, there are also tax advantages to doing so, more in Europe. But it is possible that they just have a company and they say the rights to this person's image are vested in this company, which means technically payment is made to the company. So it can just be a normal limited liability incorporated company. It's not like a special corporate vehicle. Okay, so we just talked about ways of protecting IP, and we are going to talk about the online environment shortly. But you need to remember to assess the market that you're going into. You need to be having proper contracts. You need to be clearing your rights. And if registration is available, you should also be considering whether you should register. So these are very key steps in terms of making sure you are protected. Now, again, I want to emphasize that intellectual property is very helpful, but there are limits. And we've already discussed some of these limits when we looked at the myths section for the various rights. But it is worth saying again that not everything can be protected. So just because you have an idea doesn't mean somebody cannot do something similar. They can't necessarily copy your words that you've used wholesale, but you can't stop everybody from doing something similar to what you're doing. So under each right, there are certain limits. For example, trademarks. To get a successful trademark claim, the way in which the trademark is being used must meet criteria under the legislation in the place of use. Of course, you either want to have the registered approach or the unregistered approach, but either way, the criteria is often this confusion standard. So there has to be some type of confusion taking place for you to have a trademark infringement claim. Unless, of course, you're a very famous mark like Coca-Cola, those types of marks have different provisions. Copyright, again, there are certain defenses, fair dealing, also known as fair use. So this allows people to use the word for criticism or review, for example, a book review, and educational purposes. So, for example, using a YouTube video in the classroom or using a meme in the classroom, anything like that, for the purposes of education. Then we also have persona protection. This is often going to apply in commercial settings, but there are freedom of speech limits. So having this protection does not stop somebody from talking about you. And also, if they're using your photo in a non-commercial setting, for example, it's just posted in somebody's album, you can't necessarily pursue them for that. Design rights, the real limit there is actually getting it. Education on paid online platforms are fair use. So Alberta depends on what the is meant by education in that sense, but yes, education on paid online platforms, for example, Coursera, will often be considered fair use. That being said, fair use is often a matter of assessment. So in terms of fair use, you're only meant to take as much as is necessary to convey your point, to get that point across. If you're taking more than is necessary, it's less likely to be fair. So fairness really comes into this whole fair use assessment. But yes, even in an online paid platform, educational uses can be considered under fair use. I see a question from Keston in the Q&A. Okay, so limited liability companies with a sole trader fall under these. What are the pros and cons of the sole trader company? Okay, so if you're dealing with a sole trader registration, Keston, it really depends what exactly you're trying to achieve. And the corporate form that people choose, again, really depends on what their business is. Some people opt for the sole trader because they don't want as much separation between them and the company. Some people opt for limited liability because, as with the name suggestion, limited liability gives you a totally separate entity from yourself. So it's quite a general question. I would need a bit more context to really tell you what the pros and cons would be, because it depends on what exactly you're doing. So that is one that maybe more information would be helpful. But yeah, the different corporate forms, limited liability companies, limited partnerships, unlimited partnerships, sole trader, all these things really depend on what exactly you're trying to achieve, how you want your money structured, what kind of taxes you want to be paying, what kind of separation you want from the company. Okay, so Albert is saying, I know sometimes an educational video may be placed online, but be part of the paid course, so the images used on that educational video have to get permission. All right, Albert, so it depends on how the images are being used. If it is relevant to the education, they can claim fair dealing. Now, just to be clear, fair dealing is something you claim after somebody tells you you're not meant to be doing it. So it's not an exception, as in you're not fully immunized. It's a defense that says you did it, but you were able to do it because of this defense. So often, if permission is available and easily accessed, people will get it anyway because it's something that's easier to go. But if you really are using it for an educational purpose and you're only using as much as you need, then you can claim that there is potential fair dealing there. Now, again, just because it's fair dealing doesn't mean nobody's going to tell you anything. Somebody can still say, this is mine, you should ask me, and they can say that, and then it would be for you to say, but I'm using this for educational purposes. I've only used this much of the work, and this is the outcome that I'm trying to achieve here. So again, when you have something like fair dealing, it's a defense to copyright infringement. It's not an exception to copyright infringement. So it's not that you can do this and nobody can tell you anything because it's not covered in the legislation. It is. It's just that it's a defense. So it is a judgment call in that sense. Okay, so just mentioned that not every single thing will be protected by intellectual property, but just because something does not actually have intellectual property right attached, it does not mean it's not valuable. Because alongside intellectual property, you have value being generated. So the TV formats industry, for example, the format to Who Wants to Be a Millionaire, Wheel of Fortune, all these things. In most countries, these do not have formal protection. In some countries they do, but for the most part they don't. But this is still a multi-million-dollar global industry. Different countries pay for these rights to make that version of the show within their country. So just because there's no formal IP does not mean that there's no value. IP itself, of course, adds much value as we can see, but this doesn't mean you just dismiss anything that you can't attach IP to. In addition to your IP, you will have certain knowledge and skills and know-how that can make you attractive to partner with. So by developing all this, you are creating an overall package. So for example, in a franchise agreement, IP is very important. The copyright, the trademarks being very key aspects of that agreement. But the reason people also pay, in addition to accessing this brand, is that they want to know the inner workings of the brand. They want to know what it is that you did to become successful. How do you approach certain things? So all of this knowledge can be very important. So talking about this knowledge part, if you have this type of knowledge, you want to try to secure it as far as possible. Now, once you tell other people, your knowledge can be spread. So if you have something that you really want to keep a secret, a non-disclosure agreement is very key. Now take note that if somebody breaches a non-disclosure agreement, you can pursue them for that, but the information is no longer confidential, as in you can't reclaim the confidential status of that information. But at least having this non-disclosure agreement in place can deter them from spreading information. It makes them know that there are consequences if they spread the information, and it does add this level of seriousness to whatever you are sharing. I mean, Alberta, yes, that would be an ideal situation, but we all know that is not always financially feasible. But that would be a great combination if possible. Okay, so online management of IP. Social media is very opposite to intellectual property. As we can see, intellectual property often looks to restrict and limit and protect. Social media is all about sharing, disseminating, spreading very broadly. So we can see that the social media environment has developed in sharp contrast with intellectual property environment. Keeping in mind that intellectual property has a very long history, it predates social media. And obviously when intellectual property laws were being created, they did not actually account for social media. Now there have been developments that still try to conform with social media in terms of extending, for example, copyright protection online, etc. But it's not that easy to pursue things online once it gets out of hand. So there are some steps you can take. So you want to use reputable platforms, so recognized websites like YouTube, for example. The reason you do this rather than just uploading on any website is because those types of websites have takedown and notice procedures. So you can properly track your work within those websites. And in fact, if somebody re-uploads your work, YouTube's algorithm is likely to scan it and flag it as an infringement. So those very reputable websites do have things in place. The situation Charlie described with Getty Images is actually very disappointing because they should be one of those types of sites. But generally speaking, there have been moves by major websites to really kind of try to monitor copyright infringements online. Another step you can do that is very simple is include your name on the work. If you include your name, people are more likely to be able to figure out who you are and can contact you. And I saw somebody had already mentioned that in the chat, that if you have your information on it, at least people can know who they're meant to be talking to. And again, if you have somebody else sharing your work, so let's say you're working with somebody, you create the work, just 1 second, I need to plug in my laptop. About that. All right, so create the work, but you have somebody else sharing it for you, somebody else is in charge of that for you. You want to make sure your name is included. So again, this comes to attribution. If you're working, for example, with a manager or somebody like that, you still want your name on the work. So these seem like really simple steps, and they are, but they can be very helpful. So again, on the online environment, contracts are key. So I know I've said contracts are key quite a few times, but they really can make a difference. Another thing you want to be thinking about is the type of license. Now, licensing is really a whole concept in itself, but licensing is basically the type of permission you are given. So we have something called Creative Commons, which can allow certain non-commercial sharing uses to be made. We have non-exclusive licenses that allow those who take those licenses to use the work. But we also have exclusive licenses, which means one party can use your work to the exclusion of others. So you need to consider, if you're allowing someone else to use your work, or if you're posting it online, what type of license would you attach to the right? Of course, you also want to clear the rights, as we previously mentioned, because just because something's online does not mean anyone can use it. In the same way, just because your work is online doesn't mean you want anybody to use it. Now, I also have this slide, understand how IP works on the internet. This goes back to the whole territorial aspect of IP, where many different laws in different countries can be relevant. So depending on the scope of your work, the scope of your project and the reach, there is quite a lot of knowledge that you would need to get to properly understand how your rights can be controlled. And yes, it can be very overwhelming. It can be a lot of work. And sometimes you won't necessarily want to pursue certain distributions in certain places, but it is still worth being aware of the avenues that you have. And of course, I already said this, but your moral right of attribution, you are the creator of this work. Asserting that is very important. Now, we also have digital rights management technology. And again, digital rights management technology is a whole field in itself. There are companies that specialize in this. This really focuses on copyright, because I'm sure that you would have realized from our discussion that copyright is one of the ones that can be very hard to keep track of. Once it's online, we have serious issues with things being shared, going across countries, different laws being involved. Digital rights management can help. This really regulates the material that you place online. So sometimes you might try to download a song and you realize you can't do that. You can only stream it on your platform. That's because they have put certain permissions on that song. Apparently, back in the day, if you used to try to burn a DVD, in some cases, you couldn't do that. You just get a blank CD. Is this like geo-blocking? It is similar to geo-blocking, Alberta. Geo-blocking being the permissions given to use certain words in certain territories. So yeah, it can relate to geo-blocking in terms of stopping dissemination, distribution in certain countries. For those of you who are not aware, geo-blocking really kind of is a division of intellectual property across different countries. So for example, you want your work disseminated in the Caribbean, but not in Asia. Geo-blocking can help with this because you are dividing up your rights according to the different territories. Geo-blocking relates to territoriality, which can relate to digital rights management. So in terms of how you could actually use digital rights management, it really depends on what you're trying to achieve. In terms of getting your name on the work, metadata can be included, which means you will be named as the creator. That information will be attached to the file. And of course, there are companies that really specialize in this service. They have the tools to encrypt whatever data you're looking for, to manage the file in certain ways. So digital rights management is a field in itself that companies specialize in. And it is worth considering if you are trying to protect your work, particularly in the long run, and you think you're going to have a very wide distribution, and you want wide distribution in particular, but you want control over what is happening. So digital rights management, something that can be helpful. Of course, there is a cost to this. Depends on what the company is charging, but it can help protect your intellectual property in the long run. Okay, so these are some key points on IP protection. I think we can probably all agree that copyright is the one that's going to be very difficult to manage. When you have it in an online environment is a sharing environment. It can be very difficult to really control your work. So the things that we talked about today are tools that you can use, but unfortunately there is no perfect, foolproof protection. You can see infringement take place all the time online. This doesn't mean people don't have rights, they do, but as somebody had already talked about the bootleg market, the black market in the products, these things happen. It can take a lot of time to really protect your rights, and sometimes it's just not worth pursuing because the person you're pursuing might not have money, the person might be in a different jurisdiction that's hard to track down. All kinds of reasons can make it difficult. So what you want to try to do is do your best that you can, and then pursue the very serious uses that you have the resources and are able to pursue. So digital rights management can help. Trademarks, you have to remember that there are limitations. So it's not just any use of the mark on any product. This has to be a commercial use. There has to be the confusion element. And one of the popular ways that people have tried to protect their trademarks now is through policing AdWords, which can be reported to your search engine. For example, if you have a trademark for flowers, and let's say that trademark is saffron flowers, you type that in and you realize that a competitor's brand is coming up. It could be that they have encoded your trademark as one of their AdWords, and that is something that can be pursued through the search engine, and there have actually been cases on this. I'm seeing a question in the Q&A. Okay, Alberta, so the question is registering a logo under the person's name, a person's name as a founder of company or under the company's name. Right, the ramifications of these two options. If you register it under your name, you are the one, Alberta, who would have to get permission for the trademark to be used in any setting. If you register it under a company, the company has to give that permission. If you get personally sued, the trademark is your personal asset if you have registered yourself. If your company gets sued, your trademark registered under the company is a company asset that can be pursued, which is why sometimes people register an additional company to hold the trademark in addition to the other company. So the ramifications are really the two main things, the ownership permissions that are being given and the access to the asset. So if the company is really just going to be maybe just you and somebody else, registering under the company should not be a problem, but keep in mind that when other people enter the company, if a company is dissolved or there's a dispute and somebody leaves the company, there can be issues with who is going to own that trademark. So that might be a potential problem there. So it's really an ownership structuring issue, Alberta, that you need to take into consideration what it is you want to achieve with the trademark in the long run. Okay, so as we're talking about trademark uses, remember as well that trademarks also have copyright in them, so maybe you can protect the copyright in the logo. Yes, Natasha, the jobs issue there, when companies break up or people go their separate ways, trademark can be a very big form of dispute, so it's worth keeping that in consideration. We also have this issue with a photograph of yourself being used online. Again, as we've already seen in the chat, the photographer is indeed the copyright owner. So you can't just stop the photographer from using a photo of you online unless, of course, you paid and there's a works for hire provision in your country, or you have a contract saying that you are owning the copyright. But if it's being used in an ad, then you can try to assert your persona rights. If you see a registered design being sold by somebody else, this one, even though it's very hard to get, can be fairly straightforward in terms of you can indeed pursue them. So again, a key thing to remember is that intellectual property, it does have a lot of value, but in an online environment, it is impossible to prevent every single form of infringement. Realistically, infringement is part and parcel of the online environment. So you have to pick your battles in that sense. You have to take proactive measures to try to protect yourself as far as possible, but it is very, very hard to prevent all infringement because even the share function really is very contrary to intellectual property. So in terms of what you should think about online, want to think about what sites are you using. Are they reputable sites? Do they have notice and takedown provisions? And you can see if they do by checking out the terms and conditions. Did you register anything that should be registered? Because that registration is going to give you greater protection. Of course, did you register it in your key countries of commerce? Is digital rights management something that you think is worthwhile? Will it help you? What kind of restrictions are you looking for? If you're working with other people, do you have clear contracts in place? And if you've gotten work from somewhere else, do you actually have permission to use that work, to share that work? So these are all things you should be thinking of on the online environment. And again, I want to emphasize the online environment, infringement is going to happen. That is unfortunately a fact of the social media environment, the way in which things are designed. So it really is a matter of trying to be proactive and pursuing the most serious uses, pursuing the ones that you think can be the most damaging to you in the long run. Yes, Bradley, so I have heard about this watermarking issue. Now, from an IP perspective, I would say watermark. But I do understand that many photographers are not in favor of watermarks because it impacts the way in which the work is viewed. So it is an artistic decision in terms of choosing not to watermark it. However, if you're not using digital rights management, watermarking can be a simple way to protect it. So it is something worth considering, even though I know you're probably seeing it as nearly like a compromise of your artistic expression. So it is a hard decision to make, but photography is something that can be very widely shared online very easily. For those, a simple thing to do as well, Bradley, and any photographer or any artist who's sharing work is, when you share it, do include in the caption your name and say, it depends what you're trying to achieve, right? If you don't mind other people sharing it, please say, please include my name if you share my work, and state that if you'd like to use this work in whichever settings you define, that they can contact you to take a license. So maybe just asserting your copyright in that sense can help. It's not guaranteed. There are no guarantees really, but those simple steps can make a difference. Make people think, oh, okay, this is actually somebody else's. Maybe I should be contacting them before I do anything with this work. Okay, do we have any questions on the online management of IP? Thank you very much. We are nearly to the end. We are not quite done, but I promise we are nearly there. I know it's been a lot. As I lectured UE, I do my 2-hour lectures, and I know the students find it really hard for 2 hours. So I can imagine 3 hours. It's hard for everybody, but we are nearly there. So the last thing we have to do is just look at these important agencies, and then it's just a recap. At what point does digital management become necessary? So Alberta, digital management, at what point it becomes necessary really depends on how many restrictions you want on your work. So it's going to be a personal choice in terms of, yeah, if you think your work is likely to be widely shared and you want restrictions on that sharing, then you'll want digital management. If you think your work is not likely to be widely shared, it might be less necessary. That being said, some people who have sharing that is less wide might still want certain restrictions on how the work is shared. So it really depends on how restricted do you want your sharing to be. If you're posting on things like Instagram, sharing becomes quite easy, right? So you have to take into consideration what platforms are you using, what restrictions do you want, what reach do you envision this having, and do you think these restrictions are going to be useful to you in the long run? Or do you think it's not so much the restrictions, but maybe the metadata, putting your information on it, maybe that's what you're looking for. So yes, it does depend on your reach and what you're trying to achieve. Are we able to claim from those as yet in terms of royalties? Roll, I might have missed the first part of your question. Are you able to claim from what? Thank you very much, Beryl. So Roll, I just need a bit more information online. Okay. Being able to claim royalties would first of all depend on if you could either reach an agreement with the entity that has shared your work, or if you are sharing your work yourself, what kind of revenue stream you're accessing. Remember, the mere sharing online on things like Instagram is not going to allow you to access royalties. It has to be that there's a revenue stream, which is why people like music artists tend to use Apple Music or Spotify, because there are revenue streams being generated. If there's no revenue stream being generated, then there's no royalties to claim. So it does matter in terms of revenue streams. Example, YouTube is another example of that. YouTube has revenue streams in terms of their advertising that people can get a part of. So there has to be a revenue stream for you to claim. If you just put it on Facebook, there's no revenue stream, then there is nothing to claim from. Okay, so the key organizations. Each country is going to have an intellectual property office. It might be called something else in your country. Sometimes it's called part of the registries department. Sometimes it's part of company's house. But this is a key office for you because they will have local intellectual property information. They will also handle the registration of trademarks and design rights. And if we have any inventors here, they'll handle the registration of patents as well. So your country will have an intellectual property office. You just have to figure out what it is called, because sometimes it's under company's house. There are also collective management organizations. Collective management organizations are organizations that work with the music copyright holders to ensure that they do get their royalties. So, Roel, this is one that you might be interested in as you ask about royalties. It is very difficult for an individual to fully manage their music copyright. You can imagine your music might be played in effect, it might be played on a TV ad, it might be played on the radio, it might be played in a bar. You can't exactly go around all these places and say, hey, that's my song, I need my royalties. This is the role of collective management organizations. They operate so that musicians can assign their rights to them, and they are then meant to manage all that. As to how this actually works, this is actually a big secret in all countries, how these things actually work, the actual calculations. This is not just a Caribbean problem, but a global problem. The workings of these organizations is not exactly clear or transparent. However, it is still beneficial to use them to make sure that you are getting some kind of monitoring for your music. And if you are using other people's music, it makes it a lot easier if you can just take the license from them, especially if you're using multiple sources of music. So collective management organizations really deal with music copyrights, and there will be different ones in different countries. Some of them are regional. Overall, saying he's part of an office that does pooling and collection. So different organizations do different things. Some might have different rights. So it is something that you need to take some time and think, okay, which one is for me? Which rights do they carry? We also have the World Intellectual Property Organization. Now, this is not actually based in the Caribbean. It's based in Geneva, but they do offer online distance courses. So for those of you who probably want to learn more about intellectual property, they offer online distance courses, and most of the courses are quite affordable and very informative. So it's worth checking out their website. This organization also has a collection of legislation from both countries. So if you go on it, WIPO Lex, search for that. You should be able to see laws in different countries. And I know somebody was asking about that. So that can be very helpful. WIPO also organizes seminars in the region, so you can look out for those. They might advertise through your intellectual property office. And again, it would be probably seminars like this that tell you about different aspects of IP. Additionally, WIPO often has a help desk. So in Trinidad, that help desk is part of UE. It might be part of different organizations in different countries. So you can contact your intellectual property office and ask, is there an IP help desk I can access? And often they can give you basic advice, either for free or at a very low cost. So when I say basic, it's going to be, not very highly complex issues, but it can be helpful in terms of getting your bearings around IP. So this actually brings us to the recap. We are right on time. So we did a lot today. 3 hours is a lot of time. Thank you all for staying here and taking in all this information. Today we covered types of IP relevant to creators. We spent a lot of time doing that. Thank you very much. We looked at copyright and performance rights, trademarks, both registered and unregistered, persona rights, and industrial design rights. Then we talked about the importance of IP to generating revenue, protecting yourself against claims, and of course, you want to distinguish your brand. We went on to looking at the methods of protecting commercialized IP. So I said you should assess the market, consider, can you register, should you register, clear your rights, which means you're determining ownership, and you're using properly drafted contracts. Again, people don't often like contracts, but very important. That being said, there are limits to IP. In an online environment, it's very hard to fully control your IP, and even within the physical environment, that you don't have 100% control of your asset. The limits will depend on the law in your country, and this ties back to territorial nature. But it's important to note that suing is rarely the solution because of the cost and time attached to that avenue. So in terms of good practices, you want to be using reputable websites, rights management, digital rights management if useful to you, and of course simply including your name in the work. And then we concluded with the key organizations. So we have collective management organizations, intellectual property offices, and the World Intellectual Property Organization. So that brings us right on time to the end of this webinar. I know at this point there is an opportunity for networking, so I do invite those of you who would like to exchange information to stay present. If you have any questions, let me know. If you need further intellectual property advice, I am a consultant in IP. My website is on the slide, but I'm hoping that information today was able to give you a good grounding in the basics of IP.
Okay, great. Thank you so much, Emma. Lots of information there and quite a few questions coming in as well. So great job. Thank you so much for that, Emma. I am sure persons are leaving the session today a lot more informed than they were before they came in. I know their best class yet from Dominic. Thank you very much. We're happy that you enjoyed it. So at this point, we want you to do the feedback form and the quiz. As Emma mentioned, I don't believe I alluded to it earlier, but but for those of you who have been in our sessions, you know that at this point we unmute the mics, we allow you to engage in an actual speaking conversation with your facilitator, as well as your fellow attendees. You may very well find that reaching out to persons in the session might be just what you need to do as well. So I'm dropping the links in I just dropped the links in. You can see there, the first one is for the feedback that we really do need you to complete, and we also really do need you to complete the quiz as well. So while you do that, I'm going to go ahead. I am going to unmute you. Well, you'll need to unmute yourselves really to speak, but I will give some permissions there for you to engage. Am I hearing a voice? I believe I'm hearing a voice. Let me see if I can figure. Okay, so I just muted that person, but I'm going to ask you to not unmute the mics unless you're going to speak. Please go ahead and share. I'm sure you have other questions based on what we saw coming through there in the chat and in Q&A. I am sure. But my money is on a few persons, but I'm sure that there will be some more questions coming to Emma. So please feel free to unmute your mics and speak at this time. As you complete your forms, please. That's also important.
Okay, so Alberta's asking, just make sure I'm still unmuted. Right, Alberta's asking, sometimes people use something that resemble a trademark logo, etc., but not the exact thing. Is this an infringement? Alberta, it can be an infringement depending on how similar it is. So in assessing trademark infringement, two things are taken into consideration. The first thing is are the goods and services similar to that for which you have your trademark protection? The second thing is what is being used, as in the similar logo, for example, how similar is it? Is it similar enough to cause confusion? Because the standard is confusion, it doesn't have to be an exact replica. If it's close enough, there is potential for infringement there. So yes, it doesn't have to be the exact thing. If it is similar in a way that causes confusion with the original trademark, then yes, that is potential for infringement.
Just to mention as well that we know it's a lot of information. We will be hosting the recordings on our website, and we will be sharing information via email on how to access the recordings. So you will be able to see and or to actually go over these sessions via recordings before long. Okay. Any other question that we may have from anybody?
No questions, but I must say that I really did enjoy this training with Chuck, and I'm happy that I registered, and going forward I'll be more informative.
Okay, and I see, thank you very much for that, Raul. I just, your question there about other session days, let me just share with you now. So we offered 6 modules in this program. Of course, you know, today's session is on intellectual property. We also did sessions in digital marketing, social media management, project management, managing your money, and e-commerce and online sales. And all these sessions were geared towards creatives. So the programs, the modules were specifically designed with you creatives in mind, right? We have done multiple sessions of the various modules. We are now on the final stretch of the English version of the session. This week we covered 3 sessions. We covered digital marketing, social media management, and today we did protecting and benefiting from your intellectual property. Next week, Tuesday, at 9 a.m. Jamaica time, we will be hosting the project management. Sorry? We will be hosting the project management for creative session starting at 9 o'clock Jamaica time. On Wednesday, we will be hosting the managing your money session. These are final sessions in English. And that's next week, Wednesday. And on Thursday, we'll do our final English session on e-commerce and online sales. All right. So If you haven't already registered for any of those remaining courses, I want to encourage you. We still have a few slots or spaces left, not a lot. So I encourage you to go over and to register for these courses. I think it is an opportune time to take this opportunity to also say that we will be offering the courses in other languages, not all the modules, but certainly a few of them, in Dutch, in French, and in Spanish. We will be posting information regarding these foreign language sessions on our website somewhere around the first week in November. So if you know anybody who, a creative that, might speak a different language that might be interested, I want you to encourage them to go over to the website. It's Kingston Creative, as well as the Fresh Milk websites, where the information will be posted somewhere around the first week in November. All right, as I said, we are offering some sessions, not all the modules, but a few of them in Dutch, French, and Spanish. All right. Not sure if we have any questions coming out of that. Saw something about certificates. Hold on. Once you've attended this question is regarding pass mark for to receive the certificate, or you receive once you have participated. All right, so we're issuing two types of certificates. Once you've participated, you will get a certificate to say that you have participated. However, we anticipate a pass mark of 50 and above for you to get what we call a certificate of achievement. And this one is just to say that you not just participated, but you actually was able to simulate some of the information that was shared based on the assessment that was done. All right. So hope that adequately answers that question. Let me see if there were any other questions. Okay, thank you for that, Alberta. I'm looking forward to receiving that. Yes, today. And for persons who were actually in yesterday's session, you will have received an email with the both links. If you haven't already done so, I'm going to encourage you to complete them. Okay, there's a question here regarding the certificate and how they will be received. If they'll be via email, yes, they will be there. Digital certificates that you can print if you like, but they will be sent to you.
Hi.
Hello.
Harry? Yes, hi, I'm in the call, I have the wrong link.
I'm not sure who we're talking with.
Yes, yes, hi. Yes, hi, I'm here.
Okay,
okay, no, I'm actually on another, I'm just finishing up a course I was taking. Okay, so it's at 4:15. That's why nobody's in the call. Okay. Okay.
All right. I don't know who that is. Let me see.
Yeah, man. Yeah. Okay, cool. So see you in a
wasn't able to figure that one out. Okay. So hopefully that answers that question. So the certificates will be emailed, all right? They're digital certificates that I mean everything is digital these days, right? So we will be sending them to you via email. Of course, as I said, you can print them and have hard copies of them if you so desire. All right, I see that comment there regarding the feedback form, completing the feedback questions. All right, so hopefully you would have also done your quiz as well, your mini quiz. And Alberta, thank you for that very kind comment. It was a pleasure bringing all the sessions to you and the many creatives that have joined us. We've had some very engaging sessions, and our facilitators have surely done an amazing job with sharing the information that was brought to you. All right, so I see that. I'm dropping both links in the chat again for that person who is not seeing it. There
Okay,
you
as
go.
it's being shared, I see a question from Alberta in the Q&A asking, how can one maximize IP protection and monetization for film production? Okay, Alberta, so you are doing a documentary. You want to be considering your distribution channels for this documentary in terms of really maximizing the monetization. Obviously, you will have the copyright, so you want to be getting value for your documentary. So you need to be thinking about the channels for distribution. Are you going through a local distribution channel? Are you going through international distribution channels? Are you making it available in some countries but not others? Are you having different price points for different countries? All that has to be considered, and it can be a very complex structuring process that you want to think about very early on. You might also want to think about trademarking for merchandise depending on the nature of the documentary. So I'm sure many people would have seen Tiger King on Netflix this year. If those people who created Tiger King are really on top of their game, they would have registered Tiger King, the name, for merchandise in the US to really get ahead of themselves for marketing those types of products. So you're thinking about the name of your documentary, is it worth registering? All this, of course, comes down to strict contracts in terms of if you are then making merchandise, who are you doing that through? What agreement are you entering into? For your distribution channels, how are you protecting copyright? Are you licensing it to others? Are you assigning it to a company to distribute? Are you retaining ownership? What is the royalty payment going to be? So all of it is getting your copyright clear, first of all, as into who's going to own it, because I'm sure you have, well, you might have more than one person involved in this production. So who is going to own what? That has to be discussed early on. And then what you're going to do with it, and how that copyright is going to be used also needs to be discussed, and you need clear contracts drafted for that. And additionally, is it worth pursuing the trademark route for the name of the documentary? That is not always done, but it could be worthwhile depending on what the documentary is. You think it's going to be really popular, what it's focusing on. Digital rights management might be something that's important for you as well if you're using online channels to distribute. So yeah, you want to make sure that you're sharing it through legitimate sites or legitimate distribution entities, because you don't want your documentary to end up online. Then, you know, somebody's streaming it from some bootleg site and everybody's seen it, and you're not making the money after you put in all that hard work to your documentary.
If I could just add, I see persons asking questions about the certificates. All certificates will be issued after the last English session. So no certificates have been issued to date. So at the end of our English sessions, which is next week, Thursday, we will start preparing the certificates for all the sessions that we have hosted, okay? You won't have your facilitator for much longer, so you want to make sure that you send all your questions, you put all your questions in, or you actually unmute your mic and share your comments or questions that you may have. Now is a good time to get your questions in regarding intellectual property. Thank you very much for that note regarding the session. We're happy that you enjoyed it. Kudos to you as well, Emma. There's a special mention there.
What are some of the most common pitfalls you have seen among creators in the Caribbean around IP? The most common pitfall is this not using contracts. People really don't like to use them. They think it's too defensive. But then the problem is this whole issue with when you have multiple people involved in a project, who is the owner of the project? Are there multiple owners? Who, and when money starts to make, who is entitled to that money? And how much is each person getting? So it's really the failure to use contracts, because the contracts can cover a variety of rights within the document. But if you don't have any contract in place, then you're relying purely on the law, an understanding of the law, which can be very difficult to develop because these laws are very intense, very complicated. Whereas if you have a contract, it makes things a lot more accessible and it can make this a lot more straightforward. I'm glad you all enjoyed the session. I see there's a question from Bradley. His hand is raised.
Yeah, one of the things I find, especially as a creative photographer / video, I find that with copywriting, for example, we have cost cap here in Barbados, but I see it's geared more to songwriters / musicians, and persons like myself, photographers, don't seem to be considered as creatives right to have access to copyright. So when we have infringements, the thing is that we seem to always be told to go to the law courts or whatever else. My thing is, why is that thinking like that, and why is it so difficult for intellectual property agencies or protection agencies to incorporate the other creatives?
Okay, thank you, Bradley. So that is definitely a problem where the music copyright is the focus. I think it's because historically, there's a history behind how collective management organizations came about. I think they came about maybe in France, but they really came about to protect music being distributed over wide areas. And of course, this is before we had things like the internet. So the historical focus has been on music. There are agencies in some countries that will help photographers, but it just doesn't have the same lengthy history that music has. So unfortunately, yes, photographers in many countries don't really have the same assistance. But I'm seeing somebody said in the chat in Trinidad there is some organization, rather there's the TTRRO. I'm guessing there's not the equivalent in Barbados. But I think it really has to do with the history. It doesn't mean that it's not possible in the future for such organizations to form. It's just that that has not been the path of development thus far, which is very disadvantageous to photographers, because if every time something goes wrong, you have to go to the court and you don't really have that support, it can get very costly and very difficult to police your rights. So that is just a pitfall of how things are organized right now. And maybe it's something that can be improved in the future. I see Rashad has a question. Okay, so general rule of thumb, what should you aim for in establishing a contract to feel protected and that the contract will be mutually beneficial? Okay, Rashad, so of course each contract is going to depend on what type of work you are doing and what the relationship is. In a contract, there has to be a give and take. So it depends what you want to achieve. If you want ownership and payment, you want to make it clear that this is a one-off and that you are getting certain rights, whereas the person will be paid for this work after they are paid, the relationship ends. If it is a longer relationship, for example, you see yourself entering into a partnership, you might want rights to be shared. So it depends what you're trying to achieve and how long you see yourself working with this person for. If you just want a piece of art commissioned, for example, and want the copyright in that because you want to be able to do whatever it is you desire with that art, as long as you don't degrade it against moral rights, then you will probably have a short contract identifying who is going to get the copyright. You probably want it assigned or if it's exclusively licensed, then it might end there. But if you want to enter into a longer term contract where you're working together, you might want to have a royalty sharing deal, maybe even an ownership sharing deal, or if not ownership, maybe still royalties. So it depends on what you envision the relationship to be about, how long you think the relationship is going to go on for, and what both people want to get out of the relationship. Does the person want to continue this more than a one-off? Does the person want to be actively involved? Keeping in mind that control is a key aspect of contract. So how much involvement do you want the other person to have? How much involvement do you want to have if you're entering into a contract with somebody?
Can you hear me?
Yes.
Okay, so I just unmuted myself because I figured this would be a little quicker. But I'm primarily a maker. So I'm like a graphic designer and an illustrator. And what I had in mind when I asked that question was, outside of the making of my work, what are the main sort of like intellectual property objectives that someone like me should have? Like, I'm more concerned with whether or not what I make has substance, but I know that there are ways that this should benefit me in the long run. So should I be specifically looking at things like reproduction, just general monetization, or like you mentioned control is a big aspect of contracts, but just like who has the rights to use? Like, what are the first things that I should be looking for, like with my specific occupation? Like what position should I always, I mean, just as a general rule of thumb, try to look for first?
Okay, Rashad, so since you're talking about graphic design, who has the rights to use will be very key for you because I'm sure you may have experienced this before. In the graphic design field, people do tend to take others' work. And as a graphic designer, I'm sure you probably have a distinctive style that is your signature style, something you want to be associated with. So you want to really be controlling how your work is disseminated. If somebody is paying for your work and you are giving away the rights, you might want to have a limit on what they can do with it, the context in which it can be used. You can even go down the licensing path, and if you do a license, rather than giving away your full rights to your work, that can allow somebody to use it for a period of time for a specified purpose, and that lets you retain that ownership. So if in the future you want to do something similar for somebody else because somebody feels inspired, you can then avoid a copyright infringement claim against yourself. Because the thing is, even if you created it, if you give away that copyright and you then do something very similar for another client, the first client who you gave those rights to can actually pursue you. And that is a situation you don't want to end up in. So you'd have to be very careful about that.
Okay.
Yes. So ownership, something that's very important. And in terms of monetization, the more that you're giving should be the more that you're charging. In other words, if you're giving somebody a non-exclusive license, that's a type of license you can give to multiple people. So I could take a non-exclusive license, Princess could take a non-exclusive license, Brad could take a non-exclusive license. Because other people are getting access, it's not going to have necessarily the same worth as if only I could get that license. If only I could get that license, then I'm probably going to be paying more because I'm excluding everybody else. And if I am taking those rights from you, and you no longer have copyright because you've assigned it to me, well, then I should be paying a premium because it means that you and all can't even use it anymore. So depending on ownership, there should be a monetization strategy that reflects how much you are giving versus how much you are retaining.
Okay, thank you for that. I appreciate that. Most of my work so far has been commission, but without a contract. So I kind of make those things.
Yeah.
And it's kind of like in the air because out of respect, like I did maybe like a couple album covers for a musician, and I didn't post because they haven't shared the work yet. But you know, it's like one of those things where, as a general rule of thumb, I've just been not sharing any work that I did commercially until it's been released. But because I don't really know as much about copyright as I should, I've been kind of fuzzy about that. So I just kind of wanted to ask, like, when something, you know, is kind of floating like that in the air, what is, you know, the right way to conduct myself to be respectful to my client and to protect myself?
So if you're working for somebody that wants the work kept a secret, even though you might have certain rights in the work, it is just good practice to respect that, because if it is an album cover or something like that, they're probably leading up to a launch. So just out of good general human relations, it is worthwhile respecting whatever time limit they have. That being said, you can reach an agreement where even if you fully assign your rights, they can then give you a license to still post it on your personal page, because you do want to have a portfolio of your work so that people can view it. So you might want to retain just enough ownership to publish your images. That being said, if you do assign, then you can't publish it. So it depends on what agreement you reach to with the person. It might be that they want to publish it first. They don't mind you publishing it, but they want to wait a little while. So for example, for FETs, when they have photographers, those photographers usually don't publish until after the FET has released their album. I know it's not the same thing, but it's a similar concept, right? The person who's paying you wants to have that first launch so that people see it on their platform first. So it might be a matter of saying, if it is that you're fully giving away the rights, just putting a part in your contract where you retain the rights to post on your portfolio or your personal social media accounts.
Okay, great. There was actually a question, well, more of a comment here from Jan. I don't want to miss it. It's really for you, Emma, just thanking you for a very and entirely engaging session. You really illuminated a topic that has much myth and misunderstanding around it. So a big thank you there for that. I think we also have a couple of things at the bottom. Just some thank yous, a couple more thank you. It was a fantastic session. Thank you. It was very helpful. Bradley has a comment here about sometimes I don't publish. I believe he spoke to this already. Emma, did he?
Yes, this is what we were just talking about.
Right.
Putting it out or not. I'm glad you all enjoyed it. I know IP can be a lot to take in, but it is a very important, very relevant field. And I'd also like to thank Catapult and Kingston Creative, Fresh Milk, and American Friends of Jamaica for giving me this opportunity today.
Great. It was an absolute pleasure. On behalf of the both organizations, I'd like to thank you as well, Emma, for a really, really great session. Thanks a lot. Okay, so let me ask, is anybody else completing forms? Just a show of hands, please.
A question from Alberta, which I'll just answer while people are showing their hands. So can I speak to use of music or songs in film? So Alberta, that would be a licensing issue. And as you can imagine, there are many different rights within a song, which is why the collective management organizations are very key. You would have to go to the collective management organizations in the territories that you're seeking to distribute. And as you can imagine, that is quite a lot of work because there are many different organizations. And see if the music or songs that you want to use have rights within those organizations. You might reach a situation where the music or song has not been vested within the organization, in which case you'd have to figure out who are the rights holders. If they are in the organization, however, then it's easy to just take a license, and you may be taking multiple licenses in multiple countries, depending on how much music you want to use, which songs you're using, where you're going to be distributing all of this. Somebody spoke about geo-blocking earlier, so Alberta, this might be relevant for you. The reason that we can't use the Instagram music feature, or at least we can't in Trinidad, I'm not sure about other islands, because of geo-blocking. Instagram does not have the rights to allow us to use that music in Trinidad. So they have those rights in different countries, which is why you go abroad and use it, but you can't use that feature, at least in Trinidad, because they don't have the copyright to that music. So because of the territorial nature, things like films that could be widely distributed, there is a lot of groundwork that has to be done to get all the licenses in order. So the territories in which you're planning to distribute it, if it is you don't plan, for example, if you're planning a regional distribution, that should be a little easier. If you're planning a global distribution, then unfortunately, yes, it can be very, very difficult. So you want to target the main countries of distribution, Alberta.
Emma, just confirming you've taken all the questions in Q&A, right?
Yes. Okay.
Okay.
But yeah, I think I'm covering the Q&A questions here. Let's see. All right, so Alberta, the question about the owner. The thing about if the person who created the music is still the owner, as in they have not given their rights to different CMOs, then that is fine. The problem is if they have given their rights, for example, in Trinidad to a CMO, but they did not give it to a CMO in a different country. In that case, if you're distributing in Trinidad and let's say Barbados, you would still need permission from Trinidad. So for example, even soca artists, when they're performing at FETs, they still have to get permission to perform their music if they have given those rights to an organization. If they retain those rights, then they don't have to get that permission. Similarly, if you're dealing with somebody who's retained their rights, you get permission from them. But if it is they have given those rights to any organization to patrol, you would still need to go to the relevant organization.
Can I get a clarity?
Sure.
Okay, so I want to use a song in a film in the editing process. I go to the owner. I go to the owner says, I give you permission, and I'm also registered with the copyright in that country. So I go and I get the license there to use it in the film. I was not clear. Are you saying if I'm going to distribute to the diaspora who reside in the US, what has to happen there now?
All right.
Some rights in the US?
Okay, so the thing about that is often, I assume it's a Caribbean artist you might be talking about, they might not have vested any rights in the US. So once you have dealt with them personally, and if, for example, you're dealing with any rights they have in Trinidad, that is probably your limit there because they have not necessarily gone and vested rights all over the place. It's only if they've gone to all these different countries and put their rights in these different organizations, then you need to go to all of them. But if you're dealing with somebody and they say, okay, I'm giving you permission, but I've also given my rights to an organization in Trinidad, talk to them, you talk to the organization in Trinidad, you're good. So it depends where they're given their rights to. So you won't have to go through the US because they might not have given any rights to any organization in the US.
So then I'm good in terms of I won't need to seek any additional clearance to distribute the film to the diaspora in the US because
fine because the person has given you the permission that they were able to give and you sought the license in the other place that you want to distribute it. So once the person is clear on their rights, they are able to give it because they have retained it.
Okay, thanks.
I see there are 2 hands up, but I'm not sure if they were up in relation to the form or they're up in relation to the questions.
I think they're up because in relation to the form.
Okay.
They went up immediately after that question.
Oh, one last thing. I knowing that, what about record labels now? Because I seem to realize record labels who distribute music on behalf of artists have a strong say in things.
Yes, that is correct. So if your individual has gone through a record label, there is a chance that they have given some of their rights over to the record label, in which case you need to be very clear with them, because I think sometimes people don't always realize how many rights they actually give up when they deal with a record label. If they have given up those rights, then you would need to go through the record label rather than the individual. So there was a big controversy recently with Taylor Swift, who's famous in the US, not being able to perform some of her songs. It's because the record label had retained certain rights that excluded her. So if the individual has gone through a record label, there is a good chance the record label might have quite a high level of control over copyright, in which case it's the record label you have to talk to.
Record label and not the artist.
If they've given their rights over, but it depends on what the agreement between the artist is and the record label. The artist should be able to tell you though if they've retained their rights or not. So they should be able to provide that information. If they retain their rights, then cool, you can talk to the artist. But if they have not retained their rights, then you will have to be going to the record label.
Okay, because I noticed in searching some of the music, I saw they were done on certain labels. And so whether the artist says anything, I might take it in front and go and check the record label to be on the safe.
Well, you always take it front take it, right? So if you realize that online it's saying the record label is involved in this, it could be that the artist doesn't even fully realize just how much they have given up, because these things aren't always made very clear. So it is worth just trying to figure that out, because you do need to take the rights from the person who owns it now. So that entity might actually be the record label rather than the artist. So if you're seeing those things online, it is worth trying to go through the record label to ascertain maybe they're the ones who have the rights that you need.
Okay, and then most likely I might be dealing with a deceased artist.
So as to who would have the rights to the deceased artist, again, if they did it through a record label, there is a chance the record label might still retain rights. Again, if the person didn't die, depending on which country you're in, but if the person died within the last 50 to 70 years, because it depends on the country, copyright might still exist. So if the music's not that old, copyright can still exist. And as to who owns it, it could be the record label, depending on what agreement they came to, or it could be the family who would have inherited it. So in that case, it would be a matter of figuring out, does the record label still own it, or did it revert to the family? If it went back to the family, who in the family owns it? Did they establish a company that owns it now, or did, for example, one of the children get it? So you need to make sure you're talking to the right person. It can be very complicated to figure out who actually owns what.
Thank you.
No problem.
All right, I believe the persons who had indicated that they were not finished before are now finished. So in closing, Emma, thank you again. We appreciate the time that you'd have put into preparing this session, and it certainly did pay off. We had some very rich and really engaging questions and comments coming in, and so I have no doubt that people have in fact learned or would have gotten some information that some of the information, at least some of the information that you have shared. I want to take it a step further and encourage our attendees to apply what you have learned. I mean, our job would not have been fully complete unless you put into practice what you would have gotten from today's session. So we want to encourage you to do just that. I do look forward to seeing some of you in our remaining sessions. And please continue to stay safe. Have a good afternoon, everyone. And thank you again for joining.